May I please, your lordship?
Yes.
Well, admission matter item 16, my lord. Matter regarding my lord supply of EPOS device machine, my lord. Similar matter has already discussed by your lordship on 22/12/2022 in WBC number 5470 of 2021. So, my lord, it is fully covered. Yeah. Matter may be closed.
Infectious.
Infectious. Yes.
You want to
Sir.
submit that it is infectious.
But it may be closed. It is covered by that judgment, my lord.
So when the matter is taken up, then don't you think that I should pass an order on that? And to say it to be infectious is a different aspect of the matter.
It's still infectious. It is covered by that judgment. It has already been dismissed, my lord. Similar matter.
Mr. B. Rahman, the learned counsel appearing on behalf of the petitioner, submits that the issue which has been involved in the instant writ petition have already been set at rest by a judgment passed by this court in the case of
WBC number 5470 of 2021. Dated 22/12/2022.
by judgment and order dated
22/12/2022.
22 in WPC number so and so. Nam to DDB. And as such, he submits that he would not like to further press the instant writ petition. In that view of the matter, the instant writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Hello.
Well, yeah, man, so I don't know 5, my lord.
Huh?
I don't know 5.
Huh.
Can we take up day after tomorrow or Thursday, my lord? I have some problem today, my lord.
The G. N. Saiwala, the learned senior counsel, submits that he has difficulties today in doing the, and as such, has sought for an accommodation. It's the matter after 2 weeks.
Day after tomorrow or Thursday, my lord. Yeah, I'm ready, otherwise, my lord, but I have some problem.
It's the matter again on 19th of August.
May I please, your lordship. Lordship, WBC number 1380/2024. Matter last listed on 26th July. Due to time limit, the letter didn't reach. So lordship matter may be listed again on this Friday.
For
urgency.
this Friday.
I have finally replied to the affidavit in opposition. Filed by Resolution number 5 lordship today itself. That may be called for.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 15. Here, lordship, I have to file my affidavit in opposition. So I pray for 2 weeks time, lordship.
What is the matter about?
Lordship, eviction matter, lordship. Eviction matter, lordship.
Under?
Under, it was not given under public premises act, lordship.
Then what is there to file a video? You are to take steps as per the public premises act. Then the
That
matter
liberty
will
has been
close
given
it.
to us.
You set aside that and allow you to do it in terms with the provisions of that law. That's
That
the
can be
only
done.
way out.
That can be done.
You are filing an affidavit to solve any problem? No.
Actually, lordship, today I have missed the case so long.
Do what? I'm yet to see the file. You also see the second file matter is over.
May I please, your lordship. Your lordship, we have to mention item number 33, your lordship. See, the matter has become infectious, so the matter may be closed, your lordship.
Your name?
I.H. Mr.
I.H. Laskar. I.H. Laskar, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous and as such he has instructions to withdraw the same. Taking into account the above, the writ petition stands dismissed on withdrawal. Interim order, if any, stands vacated.
May I please, your lordship. Lordship, I beg to mention item number 20, your lordship. Lordship may be taken up any
20?
other day, lordship. Item 20, 20, lordship.
Hmm.
Any other day, lordship, apart from today, your lordship.
Why?
Lordship, some difficulties there, lordship. Some difficulties there, lordship.
Interim order,
Lordship, it's not such kind of, the major decisions should not be taken by the, actually, it's a case regarding appointment of board of directors in a Samarbhai Samiti at Dibrugarh. So the interim is just to the extent that major decisions should not be taken. That's
so
all.
let them take major decisions, whoever it is.
May I please,
Who-
your lordship.
You are there?
Lordship, I have taken consent from actually Mr. S.K. Talukdar, who is appearing for cooperative societies. His name is not shown there, but it's confusing, Lordship, but he is appearing in this matter, Mr. S.K. Talukdar. Apart from today, Lordship, any date, Lordship.
Your name?
DJ Das, Lordship, for the petitioner, Lordship.
The counsel appearing on behalf of the petitioner seeks for an accommodation. This is the matter after 4 weeks.
Much obliged, Lordship.
May I please do, Lordship, I beg to mention item number 35 of for order. My senior is, with the consent of the other party, my senior is not well. He is lying on bed for 2-3 days.
It's a contempt matter.
Yes,
So we'll see what happens.
so he is ill actually.
What is your senior going to do? You have brought it to the attention of this court. A contempt matter. We'll take it up. What has happened? Let's see.
Article 34.
Hmm.
Made it close, my lord.
Complied?
Partly complied.
Mr. A.J. Atia, the learned counsel appearing on behalf of the petitioner submits that the order for which the instant contempt proceedings have been filed have been partly complied with. And as such, the petitioner does not wants to further proceed with the matter. Taking into account the above, the instant contempt proceeding stands dropped.
I am
Alright.
for response number 7. I am applying for response number 7. Aim for the charging.
Give you any-
May I please have it? May I please have it? I beg to mention item number 3. I am for the respondent of.
Item number?
3. I am for the respondent of 4 and 5. Mr. I have taken consent from the outside council. Therefore, after 2 weeks,
Why?
my senior Mr. Algota will complete me.
Who?
That's what happened. For respondent of 4 and 5. I have taken
It has been submitted that the counsel, Mr. S. Bhattakur, who is representing the respondent number 4 and 5 is in bereavement. Taking into account the above, the matter stands adjourned to after 4 weeks.
similar here in respect of item number 11 and 12. What I'm missing around. Taken consent from the previous matter.
Any stay?
Post terms.
No stay? Are you sure? Let the matter reach. I will accommodate, don't worry.
Okay. May I please, Your Lordship? Madam, the consent of the other side, I would like to mention item number 13 and 14, madam.
What is there?
My lord, in this matter also, my lord, the leading counsel is Mr. Asbot Haru. He is in bereavement matter. So, my lord, I pray for an accommodation for the.
Yeah. It has been submitted that the Mr. S. Bhattakur, the learned counsel appearing on behalf of the petitioner in bereavement, and as such, the matter stands adjourned to be lifted.
Deeply obliged, much obliged.
May please, Your Lordship. Lordship, item number 6, my lord, I am appearing for respondent number 5 to 7. My lord, I have taken the consent of petitioner, my lord. I am paying for for the day only, my lord.
What is this matter about?
My lord, his land set order of settlement officer has been challenged.
We'll see when the matter is.
But the reason is, my lord, I am not giving file, I have misplaced.
Take the second file.
I am.
Please, Lordship. My Lordship, I beg to mention case number WPC 7255/2022 to be listed on an urgent basis.
Order.
Yes, WPC, yes.
It's listed.
No,
When do you want it? Okay, next Monday.
it is a Lordship. Item number 8, my lord. I have taken consent from the other side, my lord.
Hmm.
This matter may kindly, my lord, adjourn for a week, my lord. I need to file affidavit in reply, my lord.
What is the matter about?
Matter is regarding my lord petitioner husband was expired in the judicial custody, my lord. And we have filed an FIR, my lord. We have suspected that his death, my lord, was through some suspicious, my lord. And my lord,
And when was the affidavit filed?
they have affidavit filed, my lord, on my lord, I have received on 13/10/2020, my lord,
2000?
20.
Don't ask for a genuine. Next.
What I beg to mention item number 26, madam. But in this case, I need some time, madam, to file affidavit in reply. madam.
We'll see.
One.
May I take the floor?
Yes.
The content matter, madam. We have approached the honorable court as the respondent has not complied with the direction passed by this honorable court.
What is the direction passed?
There are two directions passed basically, my lords. The first direction is in para number 20, my lords. Basically, that was an undertaking given to this court by the learned advocate general. That is on page number 34 of this petition, my lords. My lords, there is an earlier case filed. This is a case related to eviction, my lords. And we also sought some similarity from an earlier read petition where some directions were passed. In this case, my lords, para number 20, may I read it, my lords?
Huh?
Para number 20, may I read it, my lords?
20. Yes.
In the page number 34. The similarity sought to be drawn between the petitioner herein and petitioners in the writ petition WPC number 3901/2023 cannot be countenanced. 7 except the similarity of one petitioner herein, that is petition number 6 with 4 numbers of petitioner in writ petition WPC number 3901. The petition number 6 herein has been extended the benefit under the Pradhan Mantri Awas Yojana scheme, and the 4 petitioners in WPC number 390123 were also extended the similar benefits. The learned advocate general Assam has submitted that the petitioner number 6 will be extended similar benefits like the 4 petitioners in WPC number 3901/2023, as observed in paragraph 21 of the judgment and order dated 1/10/2023 rendered in WPC number 3901/2023. Such benefit will be extended if possible in a parcel of land falling within the same dark number, that is 44. And if such arrangement is not possible, then such benefit will be extended in a parcel of land in a near vicinity, along with compensation of ₹3 lakh, and such exercise will be completed within a period of 1 month. In view of such statement made by the learned advocate general Assam, no further direction is necessary insofar as petition number 6 is concerned. But in para number 22, they talk about the judgment speaks about the other read petitioners. The court has taken notice of the fact that, may I read it, para 22, Para 22 starts, the court has taken notice of the fact that applications were submitted by other petitioners other than petition number 6 claiming themselves to be deserving indigenous landless person. In view of such claim of the petitioners and contrary claims from the end of the state respondents, this court is not in a position to determine such factual dispute, and such matter can only be gone into by a fact-finding authority. Notwithstanding the rejection of the application for allotment settlement submitted by this petitioner earlier on the ground that land in respect of which this petitioner has sought allotment settlement had already been allotted settlement for government infrastructure and public playground. The court is of the considerant view that they should be given another opportunity to submit application seeking allotment settlement before the appropriate authority on the premise that they are deserving indigenous landless person and they are eligible to be allotted settlement under extended land policy 2019. It is therefore observed, having regard to the fact situation obtained in the case and taking into account the other obtaining fact situation, then in event of any of these petitioners prefer any application for allotment settlement of land under the provision of the land policy 2019 before the competent authority as per procedure on the basis that they are deserving indigenous landless person, the competent authority shall undertake a fact-finding exercise to find out the eligibility or otherwise of the applicant and thereafter consider application on its own merit as per provision of the land policy 2019. Having regard to the humanitarian aspect involved, this court.
And what happened?
Well, then we filed my lord, we filed application before the Deputy Commissioner Dibrugarh. Well, with regards to the first petitioner, no communication whatsoever from the respondents. And with regards to other petitioners, my lord, we have first of all filed an application to the Deputy Commissioner with regards to the judgment that has been passed and the observation made in that has not been complied. And after that, my lord, after 2 months, we have filed again on information to seek whether this.
You filed an application sending it by registered post.
We first went to the Deputy Commissioner Dibrugarh, my lords. Then they said that we cannot accept this application by hand. this, they did not cooperate with that, my lords. And therefore, the only option that was available to us was to file a registered post which contained all the documents and everything. There is no other option, my lords, because the Deputy Commissioner Dibrugarh office did not accept our application. We even approached the circle officer.
You
also,
have
my lords.
two other options. One is either submit your application through the Basundhara portal or file the application in terms with form number 125 and 126. Did you do that?
Basundhara application we could not file because earlier with regards to this land. For Basundhara application, my lords, what happens that in my humble understanding is that first of all we have to seek out the land which was sitting allotment for. But in this, the direction was that we'll be allotted separate parcel of land, as was being observed in WPC number 390 of 2023. In that case, also in Kusumi Sonwal, my lords, if I want to take my lords to a judgment of this honorable court in Kusumi Sonwal, 390 of 2023, my lords.
And why are you making the principal secretary a party?
The principal, since he's the head of the revenue department, my lords.
Hmm?
He's the head of the department, my lords. But in Kusumi Sonwal, the operative portion says
Notice making it returnable on 2nd of September 2024. As herein are the petitioner is directed to take steps upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. The petitioners herein are aggrieved by the inaction on the part of the respondent numbers 1, 2, and 3. And the petitioners have approached this court taking initiation of contempt proceedings against the respondent numbers 1, 2, and 3 on the ground that in spite of specific directions passed in the judgment and order dated 14/12/2023 in WPC number 6569/2023, more particularly at paragraph number 20 and 22. The respondent authorities, even in the respondents herein, in spite of being brought to the necessary formalities being completed by the petitioners, have not taken any steps. It has been submitted by the learned counsel appearing on behalf of the petitioner that the said inaction on the part of the respondents herein is nothing but a willful and deliberate violation to the order passed by this court, or to the judgment and order dated 14/12/2023, passed in WPC number 6569/2023. The respondents, upon receipt of the notice, shall file their affidavit, bringing on record their stance as to why the orders or the judgment and order, the directions passed in the judgment and order dated 14/12/2023 have not yet been complied with.
so obliged, my lords.
It is seen that there are directions issued by this court, by the directions issued by this court on 17/7/2023 for taking steps, as well as also for submission of a fresh memo of parties. This court, for the ends of justice, adjourns the matter to be listed again on 12th of August 2024. It is made clear that if no steps is taken, as directed by the order dated 17/7/2023, this court would have construed that the petitioners is no longer interested in the instant proceedings. The instant writ petition has been filed by the petitioner seeking a direction that the respondents, particularly the respondent number 3, to depute the land record staff of the Kokrajhar Revenue Circle along with police personnel to demarcate the land of the petitioner which they had purchased. This court had issued notice on 8/10/2018. None has appeared on behalf of the petitioner on court. This court, again, for the ends of justice, directs the matter to be again listed on 9th of August 2024. If the petitioner is not represented on the next date, this court shall presume that the petitioner have lost interest in the instant proceedings and accordingly appropriate orders shall be passed. Yes,
Thank you. My lord, we have challenged the impugn order, my lord. Will kindly see impugn order at page 64.
page,
For my lord, annexure 11. For restart my friend, my lord. I think, my lord, I have to file a reason that they have filed a liability.
60.
64, my lord. Oh. The expert impugn order, my lord.
Who has passed this order?
My lord, settlement officer, Dhoti Kokrajhar.
Yes. Then,
My lord, as per this order, my lord, the settlement was directed the assistant settlement officer to
so
correct,
thereby allowed the appeal.
my lord. Yes,
And
correct.
what is the ground of challenge in the writ petition?
My lord, thereafter, my lord, already land has been, my lord, corrected in the name of the respondents, my lord. Now, my lord, this land, my lord, we have passes, my lord, by sale deed, which is, my lord, annexed piece, my lord.
But Mr. Counsel, why haven't you moved the Board of Revenue? Why are you approaching this court? Against an order of the settlement officer, an appeal lies to the Board of Revenue. Why haven't you moved? Because your case is that you have, it is a question of fact that you have purchased this plot of land, which the settlement officer did not take into consideration. Isn't that a question of fact which the Board of Revenue could have very well taken note of? What is the point in filing the writ petition? Tell me.
In the revenue board, my lord, there was, my lord, delay, my lord, that, but, my lord,
So delay, there is an application you can very well file under Section 5. The Board of Revenue can very well condone the delay. Don't you think so? Why will this court take note of this aspect? Decide this. That too, when the law is very clear that if a statutory remedy is available and there is a delay, a writ cannot be initiated thereupon.
My lord, after this order, my lord, the respondents, my lord, come to this honorable High Court, my lord.
Who?
For, my lord, respondents, my lord. I approached before this High Court, my lord, for implementation of this order, my lord. My lord, that is page 67.
I'm not concerned about them. I'm asking you why you have come. What the respondent does is their lookout. That has nothing to do with
On
this.
the basis of this order, my lord, High Court, honorable High Court also, my lord, passed order directing the assistant settlement officer to a correction, my lord.
This court has passed some orders.
Yes, yes, that is page 67, my lord.
Which order?
Page 67, my lord, and it's 12.
Huh?
Page 67.
67.
Yes. Our case, my lord, respondent. And my lord, and
Due
accordingly,
consideration of the matter, respondent number 4 is directed to make correction of the in terms with the settlement court's order. The correction shall be made within 60 days from the date of receipt. Okay, then,
and my lord, by,
and accordingly correction have been made. Then,
and my lord, challenging this impugn expertise order and my lord, the correction order, we have to before this.
so you are challenging the correction order.
That is also.
Now,
correct.
are you saying this order of 10/6/2019 was passed by this court
Yes, my lord.
in your absence
Yes, my lord. We have not met party in this case, my lord.
in this writ petition?
Yes, my lord.
Then why haven't you filed a review against this order and has approached this court? Now, can this court, by way of a writ, set aside this order? You want that the order which has been passed by this court on 10/6/2019 should be interfered with?
But by this order, my lord, since correction direction was given, my lord, and accordingly, my lord, correction also met, my lord.
You see, if I am not wrong, the settlement officer passed an order whereby the name was to be inserted.
Yes, my lord.
He moved,
Expert, yes, was.
understood. Ex parte appeal order has been passed by which his name should be inserted. There was a direction. Against that, there was non-compliance for which he filed a writ petition. And that writ petition was allowed, thereby directing the respondent number 4, which is the settlement officer or whoever may be, for making necessary correction. Now, after this correction has happened, you have therefore approached this court by filing a writ petition challenging the correction order.
Yes, sir.
Now, how do I say that this order is wrong unless you file a review? Wouldn't this court be sitting or exercising a writ against an order passed by a coordinate bench? Tell me.
Even my lord, this is not expertise order, my lord. My friend is, I think, wrong, my lord, to page 64. They are not present in the proceeding. Page
Huh?
64, my lord. Page 64, the case record is put up today, which was fixed for expertise hearing and delivery of final order. The appellant is present. Respondent is found absent. They are absent in the proceeding. Now saying expertise order, my lord.
Anyway, that is a different thing. But how do this court take care of this situation? Tell me. Unless you file a suit. The only way to get over this problem is the suit.
My lord, yes, my lord. Civil suit also pending as on that, my lord.
Huh?
As on that is civil suit also, my lord, pending. We have also.
Civil
filed-
suit is pending.
Yes.
So we dispose it of that the civil court's decision will be binding and the orders which have been passed by the revenue authorities as well as by this court shall be subject to outcome of the civil suit. That is the way out by which you can now get out. Otherwise, there is no way out unless you file a review against this order passed by this court of 10/6/2019. Either file a review, which is too late. The second is you have to file an appeal against this order because this court cannot sit on this appeal, this order. What do you say? There is a civil suit pending.
Yes.
Number?
My lord, number is not, my lord, with me. Malad,
Get the number. We'll take it up at 2 o'clock. Get the number, name and number.
day after two, kindly.
For these type of matters, do you mean to say that this court should adjourn the matters?
My lord, I have tried to contact them, my lord, morning, but could not, my lord.
Huh?
That is why,
There is a suit pending.
I will take inspection. Let it be a day after tomorrow, my lord. I will also approach, take inspection, my lord.
Because the only way out is that. There is no other way out. How can this court now sit over that order passed on 10/6/2019? Very difficult. Otherwise, it's a case for dismissal. The learned counsel appearing on behalf of the petitioner submits that that in respect to the property, in respect to the land, wherein the impugned order have been passed by the settlement officer, a suit is pending before the competent civil court. He, however, submits that he would like to take the number of the suit and also the place where and the court before whom the said suit is pending, and accordingly seeks an accommodation for a day. List the matter again on 29 on 2nd of August 2024.
Published. Well.
None appears on behalf of the petitioner on call. It is also seen that the respondent is also not present. The instant writ petition has been filed challenging the order by which the petitioners have been disqualified to be a director whereby the petitioners DIN, all caps, have been deactivated in exercise of the powers under Section 164 of the Companies Act 2013 and have also sought for other consequential reliefs. List the matter again on 5th of August 2024. It is observed that if the petitioner is not represented on the next date, it shall be presumed that the petitioner is not interested in the instant proceedings. And accordingly, appropriate orders will be passed.
The Lordship, this matter may kindly fix after day after tomorrow, my lord. In the meantime, I will file my affidavit.
E. Deori.
R.S. Deori.
Ms. R.S. Deori, the learned counsel appearing on behalf of the petitioner, submits that the affidavit in reply to the affidavit in opposition filed by the respondent number 2 is ready and would be filed in a day or two. Taking into account the above, list the matter on 12th of August 2024. The petitioner is given the liberty to file their affidavit in reply, if any, by 9th of August 2024.
Deeply obliged.
8 million lordship. I have received a affidavit filed by the state government, but regarding respondent number 6, my lord. The National Highway Authority, because they have acquired the land, my lord, and have widened the national 37, my lord, NH 37. Now
Your
my-
land has been acquired.
Yes, my lord, and they have, my lord, constructed the highway, my lord, but my building has been, my lord, demolished. Half of the building has been demolished. Now I have not received any compensation from the authority, my lord. Now this National Highway Authority, who is appearing, I don't know, my lord. Earlier notice was issued, subsequently they made party, my lord. I have not received any affidavit.
Huh?
I have not received any affidavit from this NH, National Highway Authority of India.
NHI has filed the affidavit in opposition as far back as in 2022.
Then, my lord,
Everybody has filed affidavit.
well, this notification was published during, my lord, COVID-19 period. At that time, proper, my lord, objection or anything, my lord, petitioner could not submit. At page 33 is the, my lord, building, my lord, owned by this petitioner. It was constructed long back, my lord. It is, my lord, demolished now. Is subsequently demolished during the pendency of this, my lord, writ petition, my lord.
NHAI says that they are not constructing any road. The this deputy commissioner files an affidavit that you have nothing to do as regards the land. So better of you, if it is done under the National Highway Act, go under 3H. There's no way out. Dispose it off, giving you the liberty.
Yes, my lord, delivered.
That is the only way out.
Because, my lord, this building,
The heard Mr. R. Goswami, the learned counsel, appearing on behalf of the petitioner. Mr. S. Borua appears on behalf of the respondent number, the state respondents. None appears on behalf of the National Highway Authority of India on call. The petitioner herein is aggrieved on account of not granting of compensation in respect to the land acquired of the petitioner. It is the case of the petitioner that the petitioner is the absolute owner of a plot of land measuring 3 katha 14 lechas under dark number 2246 bracket old in patta number 18 old in village Dergaon, Moza, Dergaon in the district of Golaghat. He further states that after the partition being carried out, his name was recorded in the Jamabandi under dark number 3191 of Patta number 54, covered by 8.75 lesser first class commercial land. The said land was at the stage of acquisition. It is also the case of the petitioner that the petitioner had also constructed a building over the said land.
A portion of which is already demolished.
It is the further case of the petitioner that the said land is a part of the notification issued in terms with section 3C of the National Highways Act 1956. However, the respondent authorities not only have demolished a part of the building which stood over the land in question and have taken the said portion of the land, but the petitioner have also not been paid any compensation. It is under such circumstances that the instant writ petition has been filed. Pursuant to the filing of the instant writ petition, it is seen that the Deputy Commissioner Golaghat had filed an affidavit in opposition, wherein it has been mentioned that the land measuring 0.0078 hectares, bracket 6 letters, covered by DAG number 2246 under NKP number 18 of Dergaon town under Dergaon Moja have been acquired for construction of bi-lane connecting to 4-lane road. It has also been mentioned that as per the report of the circle officer dated 26/10/2021, based on field verification by the Lot Mandal, it is seen that the following persons, namely, number 1, Sri Niren Bhattakur, number 2, Sri Chandan Bhattakur, number 3, Sri Santanu Bhattakur, number 4, Sri Sumanta Bhattakur, all sons of late Surakanta Bhattakur, comma, number 5, Sri Dilip Bhattakur, number 6, Srimati Anjali Bhattakur, number 7, Sri Satyajit Bhattakur, and number 8, Srimati Rumi Bhattakur are the actual pattadas of the said land acquired for 4-laning the NH 37. It has also been mentioned that the name of the petitioner is not included in the land acquired out of DAG number 2246 of NK number 18. And as such, the petitioner is not entitled to any compensation besides the object compensation. It has also been categorically mentioned in paragraph number 6 of the said affidavit that DAG number 3191 on which the petitioner claims right have not been acquired or is a part of the notification issued under the National Highways Act 1956. This court have also heard the learned counsel, Mr. R. Goswami, as well as Mr. S. for the petitioner and Mr. S. Borua appearing on behalf of the respondent. In addition to that, this court have also perused Annexure 1 to the writ petition, which is a part of Annexure 1 to the writ petition, which is the notification issued under Section 3C of the National Highways Act 1956. From a perusal of the said notification, it is not seen that DAG number 3191 have been is a part of the acquisition proceedings.
Serial number 84, 2246, newly new drug dealer.
On the other hand, however, Mr. R. Goswami submits that tag number 2246/MK18 is the land which later on was renumbered as tag number 3191. This court, taking into account that the issue which have been involved as to whether the petitioner land have been acquired or not, and there being a specific denial to the effect that tag number 3191 have been acquired, is not in a position to decide the said aspect of the matter, taking into account that serious disputed questions of facts are involved. It is also seen that there has been no affidavit in reply filed to the affidavit in opposition by the respondent number 3. Taking into account that these are disputed questions of fact, and if the petitioner is entitled to, the petitioner can very well, the petitioner can very well agitate the said aspect of the matter in the proceedings under section 3(H)(4) of the National Highways Act 1956. Accordingly, this court is not inclined to entertain the instant writ petition for the reasons aforesaid. However, grants the liberty to the petitioner to approach the concerned court in terms with section 3(H)(4), H2(4) of the National Highways Act 1956, if so advised. It is further made clear that if the petitioner approaches the said court within a period of 30 days from today, the same shall be taken up. The said application shall be decided on merits.
Respondent number 4 has filed affidavit. 1, 2, 3. They are the prime respondent. They have not filed affidavit.
What order you are setting aside?
My lord, I challenge the order annexed 25, page 79, my lord.
Page 79. What is that order?
I executed a contract work of construction of the building of Silchar Municipal Board. That was in 2 parts, Block A and Block B. Block B I have duly completed to their satisfaction. Block B work I cannot work because the whole office was running there, and this is an admitted fact in the impugn order matter. They could not give me site. So the period almost came to the end. And thereafter I said that unless and until there is escalation, I cannot do this work because the site was not handed over to me. So in consideration of that, municipal board has cleared my all bill. They have accepted to that extent. Only my earnest money and security deposit was not released. So finally, that was also approval of short form director regard for release of the money, my lord. While the matter is pending as such, my lord, the additional deputy commissioner, who is the ex officio executive member of the Central Municipal Board, he has passed the impugn order imposing a penalty of 53 lakhs. So deducting my claim of earnest money and deduct security deposit, 16 lakhs have been directed to the state. That is under challenge here. Now, Silchar Municipal Board, so far the director has filed his affidavit. He has said that he has nothing to do with the release of payment. This is Silchar Municipal Board. They will do whatever they want, madam. Director is saying.
But he's also the executive officer.
But he has relied on some audit report, CAG audit report, without giving me notice. And my lord, all works were assigned by Silchar Municipal Board. The question of jurisdiction is also there, my lord. Our ADC, executive officer, my lord, can pass this order, my lord. The order and everything was given by board. He has passed this order, my lord. So these are the things, my lord, and factual thing also, my lord, regarding handing over the site and all, the municipal board has to respond, my lord. Only thing is that whether there was substantial delay in handing over the position of block A or not, my lord. They have admitted in the.
Well, Mr. Chakraborty, why should we go into those aspects of the matter in a writ?
If the matter is admitted, then this panel order is, my lord, absolutely arbitrary, my lord. This panel order is absolutely arbitrary, my lord.
Let us see your order by which you have been handed over the document, your work order.
Work order, my lord. Letter of acceptance was page 29, my lord. Formal work order is page 52, my lord.
And what are the terms? Terms of your work order, what are the terms?
Contract agreement, page 34.
Huh?
Contract agreement is page 34.
Which is the clause for compensation?
That's 5.
Was the Silchar Municipal Board at that point under supersession? When the order was passed? Was it under supersession?
That was functional, lord.
Yes, Silchar Municipal Board. Then
Yes,
how are
sir.
you imposing?
We have relied on clause 5, 6 and 42. Ma'am.
Understood, very well. You have the power, there's no quarrel with that. But how is the additional deputy commissioner or the executive officer taking over, doing it when the mandate of section clause 5 is either by the director, chief engineer and the executive engineer? How is it possible?
Lord, because the executive officer is the person who will see the overall function of the board.
Absolutely.
So
But-
therefore,
But can he take a decision? But when the contract categorically says the director, the chief engineer, or the executive engineer, they are the three persons who are to do it. Okay, understood. The director may do so, or the board may do so. But did the executive officer, because in terms with section 53,
yes,
in terms with section 53 earlier, and now it is being amended recently, but earlier section 53 categorically mentioned that whatever decision he takes, he has to take with the concurrence of the board. He can't do it on its own.
but that relevant time board was not functioning.
That is why I asked,
It was
was the
superseded.
board under supersession?
Yes, supersession.
How do you know?
Because the executive officer was functioning at that time.
Executive officer will always be there,
No, but
irrespective of the board being
No.
there or not.
If the board remains, in that case, my lord chairman will be there. And when
But
the
then also the executive officer will.
executive officer is there, but since the board was not functioning at that time, it was superseded body. So therefore, executive ADC was inducted as an executive officer. So he passed that order. You also will find that at page 79.
When did you pass the order?
That was on, my lord,
21st of December, my lord.
21/12/2020.
2000?
20, my lord.
And when the contract ended,
That was 2000.
you grant
Agreement-
an extension
Agreement was, yes, it was extended.
by you.
It was not, my lord. They said that it take extension regarding block A, but they were not ready for escalation. That's why
Whether the block A was extended.
block B was completed within the tenure, my lord. Block A handover was not given, it could not be started, my lord.
Oh no, whether it was extended.
They asked for taking extension, but the dispute arose because I was asking for escalation, my lord, so it did not work out there, my lord. They have paid or cleared all the bill, my lord. They have cleared all the bill. Kashim, may kindly see page 73, my lord, the view of the board, my lord. Page 76, my lord, 73 and 76. Three minutes, last line, he said that my work, the earnest money will be refunded to me. And 76 says that asking for as you kindly see, it is a letter to the director saying that give approval, we have money, we have to clear the dues of conductor. Now, director in his affidavit saying that our approval is not required, SMB can pay on their own, my lord. The impugn order, page 79, is clearly mentioned that site could not be handed over till December 13th.
But Mr. Chakraborty, how do you conceive that this court would decide this aspect of the matter as to whether they have given it or not?
My lord, page. Their
Is
own
it your
document-
statement categorically anywhere that the board was functioning at that point of time? In
My
your
lord,
interpretation?
I have shown your lordship that order That is the later 2000 till July 2018 board was
We
working.
are not
that later-
concerned. We are concerned at the time in 2020. And there is also a cancellation of the work order. Which means there was an extension.
Yes.
Did you accept it under the extension?
That later cancellation.
So at any point of time to these authorities, then look here, give me more time. Or did you, when they granted you the extension, did you again write to them? Yes, but I need more money for that.
And these letters are there, my lord. The representations are
But these
there.
are expecting the matter, how can this court decide under 226?
The only issue is that, my lord, the dispute was regarding that the site was not handed over to me. And they have cleared everything.
However, the impugn order categorically says that the site was handed over.
No.
Yes, kindly see,
That page 79, yes, lord.
kindly see this, I've seen that order.
We clarified.
Kindly
it
see
was
here.
handed over.
Second paragraph.
Paragraph 3, paragraph 3.
Paragraph 2, lordship, kindly see.
On the paragraph 3, that the erstwhile chairman by the letter dated have already informed you. I would like to inform you that the work site has been handed over to you long back on 1/8/2012 and you have executed the western part of the construction. So there is no question of handing over the site once again.
Exactly, my lord.
Then-
This letter I have enclosed. This is a blatant lie because the earlier page, lordship, kindly see, paragraph 2. This is a blatant lie, my lord. They said that no, it was handed over. Handed over block B. Block A, lordship, kindly see. As soon as the office started to work in newly constructed building in December 2013, all the assigned type and dilapidated building of the were demolished by SMB. The room where chairman and vice chairman used to sit was vacated in December 2013, but not demolished by SMB. They are the function, the board was functioning. So only 7 months left, my lord. Their own admission that in December, the board, they were occupying that block M place, my lord. Now, earlier, when I said, my lord, you have not handed over, they gave this reply that long back it was handed over to you. The penalty has been imposed only based on some audit report. Without hearing me, what is this audit report? Nothing is. Had a hearing been given, my lord, I would have pointed out all these things, my lord. How can I carry out
No,
construction when the site,
in a contract, is it conceived of to give you a hearing?
my lord?
In a contract, is it conceived of to give a hearing to you?
Panel order, if the panel order is passed, my lord, penalty is imposed. In the backdrop of this fact, my lord, notice is required, my lord, the panel order. Not a contractual order, my lord, is imposed a cost not on me, my lord. This is one of my submission, my lord. The panel order,
These are absolutely within the realm of the commercial contract. You have entered into, and if there is any thing to be done, it should have been done before the civil court.
if the default is on my part, my lord, they can do anything within the ambit of the contract. If the default is on their part, my lord.
That is the question which to be decided in the forum, proper forum, not this court. How can this court decide as to whether the default was there or not?
If the response comes from them, my lord, they have not filed affidavit till date, my lord. Then certain things will be clear, my lord.
This is a repetition of 2022. Order was passed in 2020. You file it in 2024.
And the COVID period is there, my lord. You can appreciate, my lord. COVID period is there, my lord. So 2021 COVID period is there, my lord. So
No, for you, they have taken 2 years. So they are now he is also taking 2 years.
my
There are questions of facts. How can this court enter into this?
I am relying on their document by which they are admitting that they did not hand over the possession of the site, my lord. Is their document, impugn order, my lord.
Where?
But that impugn order, Till December 2013, the office was functioning in Block A place, my lord.
But then also the order was passed in 2020.
Yes, my lord, 2020.
Yeah.
The imperial order,
Let us assume that 2013, as soon as the office work started for the newly constructed in December, they all, sometime a long way was demolished by the SMB. The room where the chairman and vice chairman used to sit was vacated in December, but not demolished by the Imam. It is to be noted at this point of time that as per so and so, every year the contractor is required to remove all shrubs accessible. So then, these are questions of facts. You need to file a suit.
my lord, the fact, if they can dispute in their affidavit matter, they can dispute that I was responsible for the delay or there was some lapse on my part. Then of course, some disputed question of fact arises. But certain facts which can be clarified through document. ABL International says that.
They are categorically saying that in December 2013, you were given.
Yes, ma'am.
The contract was terminated in 2020. What were you doing all this while?
No, no matter the tenure of the contract came to an end in July 2014.
Where are the documents by which it has been extended?
It was not extended, my lord.
So if it is not extended, have you made a statement that it was never extended?
My lord, that
Because the
document,
contract was for 2 years.
my lord, petitioner was asked to attend a meeting. These are representation, number of representation are filed, my lord, regarding the delay and everything, my lord. Then finally, board has said that we want to pay director's approval of sort for. And finally, this order was passed by executive engineer, my lord.
Is not the forum.
So my submission is that only dispute is that whose lapse it is, whether they did not give the site or I failed to execute the contract, my lord. If I fail to execute, my lord, I am liable to face penalty, my lord.
You on the if we look into the documents, the contract agreement says 24 months.
My lord.
After 24 months, whether there was an extension,
No extension, my lord.
If it was
I have
not
to look into
extended,
this, my lord. This issue I have not seen.
so the period ended in 2014.
14, it ended, my lord.
After that, if there was no extension being granted in 2020, how could they have imposed the penalty? Couldn't it be a case where it had a flux? The contract had become impossible in view of not handing over. Would you not be entitled to compensation? These are various aspects of the matter which ought to have been decided in the civil court. How can these courts decide all these things? At the end of the day, you are going to lose here. Telling you, Mr. Chakraborty, and no court will pass an order to that effect that he is wrong, he is right. Again, we'll send it for consideration, and again they will come up with the same thing.
Alright.
If you want to get the relief, that is the only way, by filing a suit if there was no arbitration agreement clause.
The arbitration was not there. Arbitration was not there.
So the only way is to file a suit and get an injunction that this amount should not be recovered from you. And ask that you are entitled to how much amount of loss of profit. These are various aspects which you can very well ask. By asking only for the earnest money and the security deposit, which you are entitled to. But how can this court decide all these things? Tell me.
Lordship is very correct, my lord. Only we have filed this petition only to the extent that on the face of the record, they could not hand over the site. On the face of the record, my lord, this order was passed by executive engineer. Now they are saying that the municipal board was not functional. That instruction I don't have, my lord. So my lord, apparently it was without jurisdiction and all.
Because another aspect of the matter is, if it was not functional, it's okay, the executive in charge. But if it was functional, he had to take the approval in terms with 53. That is another aspect of the matter. On the question of jurisdiction, that is the aspect which this court could have very well taken. But at the end of the day, you are again liable to. On the other hand, if I pass an order to the effect that all these things, taking into account the COVID and all this pendency is taken away and you file a suit out there, you'll ask for many things. That period of those 2 years and these 14, you get the benefit and then go there and file it. That is the only way out. I'm trying to help you out, but if you want that at the end of the day, this matter be pending, very well. What is there? Let me go and help somebody else.
My lord, can I have 1 day's time for taking? this
No,
action?
let him take time. How much time, Mr. Datta?
For filing affidavit.
Absolutely.
Actually, he wants me to file affidavit.
He wants, you don't want to file.
All right, my lord, your lordship.
If you don't want to file, we'll consider it, that he doesn't want to, we'll deem it that it has been deemed accepted. There is no affidavit filed by the executive officer also. Or by the additional deputy commissioner. He's a party. No?
If
So
your
will
lordship,
be deemed on the question of doctrine of non-traverse.
if your lordship want to go in that line, my lord, in that case, obviously,
I don't want. It's not that he wants you to file an affidavit.
In that event, your
He
lordship.
wants 1 day only for the purpose of what should be done. Should he be remitted back to the civil court? That is what, giving him the benefit of the limitation. That he is wants.
Yes.
I'm asking you
In
whether
that
you want
2 weeks time.
Mr. S. Dr. the Learned Senior Counsel appearing on behalf of the Silchar Municipal Board admits that he wants to file an affidavit in the instant matter. It is seen that the notice was issued as far back as on 4/4/2020, on 23/2/2022. And almost more than 2 years have elapsed in the meantime. Under such circumstances, a last opportunity is being given to both the Silchar Municipal Board as well as the respondent number 3 to file the affidavit. To list the matter again on 21st of August 2024. In the meantime, the affidavits be filed on or before 16th of August 2024.
Obliged.
But that is the only way out.
I have enough. I'll take note of that.
Yeah. Because that you will get everything.
Oh, okay.
Yes, Mr. Vishwakarma, where is he?
Morning, I have mentioned,
Understood.
there is no interim order. Notice was issued.
Okay, it has been submitted at the bar by Mr. What's your name?
He will.
T. Gugoi, the learned counsel assisting Mr. S. Bottakul. That, have you filed your affidavit?
Lordship, my lord, in WPC 6431, which is not listed to that, in that matter, we have filed a comprehensive affidavit. That affidavit will cover this, this two matter also.
That matter is here today.
No. My lord, lordship. will take, this
It,
matter-
it has been submitted by Mr. D. Gugoi, the learned counsel appearing on behalf of the missing autonomous council, that a similar issue in respect to that there are other there is another petition wherein similar issues have been raised in respect to the in the said petition being WPC number
6431,
6431/21,
Lordship.
2021, an affidavit has been filed which would cover the dispute involved in the instant proceedings. Accordingly, list this instant petition with WPC number so and so on 28th of August 2024.
My lord,
So where the counsel appearing on behalf of the petitioner is directed to on behalf of the missing autonomous council is directed to serve a copy of the affidavit filed in WPC number so and so to the counsel for the petitioner. during the course of the day.
Will be similar.
Is same,
Same.
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 Itu একে order to you. Aku itu লিখি দিব list repetition along with so and so লিখিছে ন itu. আগত itu itu.
Hello.
This is some land in the missing autonomous council, na?
Missing Bhavan. Missing Bhavan. Missing
Hmm.
Bhavan.
Because that day, while I was taking up that matter, it had come.
Hello.
That pertains to the eviction of railway land loss. Eviction order page 22 was passed last year without following the due process.
This one,
Yes,
page 22.
yes, ma'am. I am running a small shop, lordship. That paragraph. two, I
Or
am-
Mr. J. Abbas, the learned counsel appearing on behalf of the petitioner, Mr. and Mr. S.S. Roy, the learned counsel appearing on behalf of the NF Railway. The petitioners, how many? Petitioner herein who carries on the business of a shop of retail in the name and style of MSJ Matadi Enterprise has approached this court challenging an order dated 8/7/2022 passed by the senior section engineer works NF Railway Moriani on the ground that the action taken by the said officer was contrary to the well-settled principles of law. It is seen that it is the case of the petitioner that the petitioner is in occupation of a plot of land and carrying on the business since long. The counsel for the petitioner submits that the responding authorities, even assuming that they are owners of the land, they can take steps for eviction only by following the due process. In that regard, he made reference to the provisions of the public premises unauthorized occupants. What is that name?
Eviction of unauthorized occupants. Page 59.
Public premises eviction of unauthorized occupant Act 1971, which stipulates a particular mode by which steps can be taken for eviction. Full stop. The learned counsel for the petitioner further submits that such an action can only be taken by the estate officer and not by the senior section of engineer, as have been done by the impugned order dated 8/7/2022. I've also heard Mr. S.S. Roy, the learned counsel, appearing on behalf of the NF Railway. This court duly takes note of the provisions of the Public Premises Eviction of Unauthorized Occupant Act 1971, which stipulates a manner in which eviction of unauthorized occupants can be dealt with. It is an admitted fact that the NF Railway has an estate officer. Under such circumstances, the action taken by the senior section engineer works to issue the notice for eviction dated 8/7/2022 is not in consonance with the provisions of the Act of 1971. Accordingly, the impugned order notice dated 8/7/2022 is set aside and quashed. Before parting with the record, this court, however, makes it clear that the setting aside of the notice dated 8/7/2022 shall not bar the NF Railway authorities to take action in terms with the provisions of the Public Premises Eviction of Unauthorized Occupants Act 1971. With the above, the petition stands disposed.
Okay.
17.
What are you challenging?
That is relating to HPSCI, Your Lordship.
1511. Why?
8/7/2015.
How?
Accident.
Accident. What accident?
Motorcycle,
Knocked,
Huh?
a motorcycle knocked in.
Which motorcycle?
15/8/6.
Okay, so under such circumstances, how is the writ petition maintainable? In view of the judgment passed by the coordinate bench,
petition 2700.
you can very well file an MAC claim. Lahok,
I don't know what that-
urge so and so, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent's state, and Mr. A. Bhattacharjee appears on behalf of the Revenue Department of the Government of Assam. The petitioner herein have claimed have approached this court being aggrieved by the inaction on the part of the respondent authorities in releasing the ex gratia amount of rupees 2 lakhs in terms with the notification dated 15/11/2014. This court duly takes note of the materials on record, including the FIR which have been filed. In the said FIR, it is seen that a two-wheeler bearing registration number AS 1586002 had hit the father of the petitioner from the backside, and
Husband-
the father of the petitioner,
husband of the-
Huh?
husband of the-
the husband of the petitioner, Dilip Mehdi is not here. Husband of the petitioner. The husband of the petitioner from the backside, and accordingly, and thereupon, the husband of the petitioner succumbed to the injuries and expired. It is also seen that the FIR was filed in respect to the said incident. This court takes note of the judgment passed by a coordinate bench of this court dated 21/6/2024 in the case of Monisha Khatun, alias Monisha Khatun versus the state of Assam and 5 others. The bracket WPC number 2700/2003-23. In the same judgment, the coordinate bench of this court categorically held that the notification dated 15/11/2014 cannot be read to be applicable in respect to all accidents except hit and run case where the offending vehicle remained unidentified in the final form after the police investigation. This code, paragraph 16-17 of the said judgment is reproduced hereunder, taking into account the above, taking into account the above proposition as laid down by the coordinate bench and the fact that the vehicle in question which had caused the accident has been duly identified, the petitioners herein would not be entitled to the benefit in terms with the notification dated 15/11/2014. Be that as it may, that the petitioner herein would be otherwise, be that as it may, this court observes that the instant order shall not preclude the petitioner to avail other statutory remedies as provided under the Motor Accidents Motor Accidents Act, Motor Vehicles Act 1988.
18.
Why? What is it going to save you from at 2, which is not going to do it now?
My lord,
Tell me, what is your case?
Sir, landless person, my lord.
Not issued the restraining the respondent number 7 under so and so causing their arrest on the petitioner in possessing the impugned plot of land and so and so. What land is this?
The lands are allocated to them, my lord.
Huh?
These lands are allotted to them, my lord.
Then?
But the police, my lord, they are disturbing their, my lord, position, my lord. The land is allotted to the government, my lord, annexure 1 to 15, my lord.
Then why are they disturbing you?
That is, my lord.
Why are you disturbing?
All the records as related to the allotment of land is with the CM Resilience, and already circle officers has been strictly instructed not to disturb the petition.
Could not be verified as all documents of allotment of 2000 were seized by the CM Vigilance so and so. The circle officer has been instructed not to carry out eviction without prior notice as ordered by the High Court. Well, how much time will it take? Where is the order of eviction?
No order.
No order.
No order.
Then they are disturbing you.
Please, my lord, police person.
Huh?
Police person is disturbing me.
What is the police doing all these things? It's for the revenue to do whatever it is. What is this police doing? Please respond number 7. Okay? Outpost. What is he doing?
That is the allegation brought by the petitioner.
If there is an allotment given or not given, that is for you to look into. But why will the respondent number 7 do all this mischief out there?
Those are the allegations that the petitioner has leveled. So there is nothing to substantiate.
Here the direct, what is he asking, that the respondent number 7 police officer so and so from causing any disturbance or harassment to the petitioner? See, if the petitioner, if any action is to be taken against the petitioner, it has to be either taken by the district commissioner
Yes, sir.
or to the circle officer.
Yes,
Yeah.
yes.
The respondent number 7 independently cannot take any action.
Yes.
We allow this to be saying that, okay, don't disturb. The district commissioner or the circle officer may do so, provided by following the due law, and the respondent number 7 independently cannot take any action. Matter over. What do you say, Mr. V.K. Borua? That is the only thing you want. And you cannot say that the police can go anywhere and do everything.
Allegation that he has brought in.
So his relief only is to that extent that respondent number 7 should not disturb. Okay. Let the district commissioner do whatever it is as per provided under law. And respondent number 7 cannot independently exercise any authority except through
When directed by
the district commissioner.
simple.
Chalo, we'll come at 2. Yes, Mr. Day. This land was allotted. Then there is some 144 proceedings.
144 proceeding when some people from Meghalaya, they claim that it is their land. So while there was a 144 proceeding, it was converted to 145. Then restriction was withdrawn. And now we are in possession. The circle officer's report, the extent settlement officer's report is there, Melon. It is not land within the Meghalaya, it is within Assam. Boundary is about 4-5 kilometers away from this property.
Now the problem is the respond number 7.
Fine.
But is the office of the respondent number 7 the problem or the person is the problem?
The person.
The person is not a party.
An officer in charge, madam. Officer in
Understood.
charge.
Therefore, I ask whether the
saying when a
office,
person might not
officer
take
in
the
charge,
check,
that is
no
the
order,
office is the
but
problem.
Verbally, orally, he is threatening us to evict. This is the problem. He is holding the post of officer in charge.
Hmm?
He is holding the post of officer in charge.
But that's the person who has done that. But that person is not before this court.
Officer in charge is before your lordship. Madam.
Heard Mr. KKT, the legal counsel appearing on behalf of the petitioner. Petitioners. The S. Borua appears on behalf of the respondent number 2 to 7. And Miss so and so appears on behalf of the respondent number 1. The petitioners herein have approached this court alleging that the respondent number 7 is interfering with their possession. without following due process. From the perusal of the materials on record, it is seen that the petitioners herein were granted allotment by the government of Assam of various plots of land. It is also seen that the lands which were allotted to the petitioners are situated at a distance of 4 to 5 kilometers from the state of Meghalaya. It is also noticed that there were certain encroachments, and it is also noticed that there were certain alleged encroachments by third parties to the land, for which 144 proceedings under the Code of Criminal Procedure 1973 was initiated, but subsequently relaxed by the executive magistrate. The grievance of the petitioners in the instant writ petition primarily is that the respondent number 7, who is the officer in charge of Kalapani outpost under Mankasar police station, have verbally informed the petitioners to vacate the land. And as such, the petitioners have submitted representation to the concerned authorities, including the Deputy District Commissioner, South Salmara, Mankasar. However, no action was taken. It is under such circumstances the instant writ petition has been filed. Pursuant to the filing of the instant writ petition, this court, by an order dated 30/7/2022, directed, while issuing notice, directed that the petitioners shall not be evicted from the land under their occupation pertaining to dark number 94/78 without serving prior notice upon them, giving 15 days clear time to respond. The said interim order have been extended from time to time. Today, when the matter has been taken up, it has been Mr. S. Borua, the learned counsel, appearing on behalf of the respondent number 2 to 7, submits on instructions issued by the additional Deputy Commissioner, South Salmara, that the claim of the petitioners could not be verified as all documents of allotment of 2019 were seized by the CM Special Vigilance Cell, Assam, in connection with CM Vigilance PS case number 5/2021. It has also been mentioned that the circle officer the assistant circle officer have been instructed not to carry out eviction without prior notice as directed by this court. This court I've heard the learned counsel appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondents. From a perusal of the documents, there is no affidavit in opposition filed by the respondent authorities in spite of the notice having been issued in the year 2022. There is no denial to the allotment letters, certificates of allotments which have been issued to the petitioner and closed to the writ petition as Annexure 1 to Annexure 15. From these documents, it is apparent that the petitioners herein have been granted allotment by the Deputy Commissioner, Harsh Singh Mari. Under such circumstances, it is the opinion of this court that if the said petitioners, any steps for eviction of the petitioners are to be taken, the same has to be taken by following the due process. As stipulated in the settlement rules of the Assam, framed under the Assam Land and Revenue Regulation 1886. Under such circumstances, in that view of the matter, the respondent number 7, who is an officer in charge, cannot act independently to disturb the possession of the petitioners. Accordingly, the instant writ petition therefore stands disposed of, thereby directing the respondents to not to disturb the possession of the petitioners. Without following the mandate as specified in the law, under the provisions of law. It is, however, it is further made clear that the respondent number 7 independently has no authority or jurisdiction to interfere with the possession of the petitioners. The above observations and directions the petition stands exposed.
We have been instructed, my lord, the petitioner has got the relief as prayed for in the present writ petition.
Mr. M.M. Mondal, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the relief as sought for in the writ petition. He therefore submits that the writ petition has become infructuous. Accordingly, the instant writ petition stands closed as it has become infructuous. The interim order, which was passed on 7/11/2022, therefore, stands vacated.
Lordship. Lordship, here in this matter, Lordship, the petitioner was has challenged the 3 notices, Lordship, that were filed by the department, Lordship, the income tax.
Huh?
The 3 notices, Lordship, that were issued against me, Lordship, for filing returns for the assessment year, Lordship, 2015, Lordship, 2016, Lordship. However, Lordship, the impugned proceeding, Lordship, pertains to the year assessment year 2015 and 16, and they cannot do anything, Lordship, against me because, Lordship, the 3 years period of limitation will come, Lordship. So since it was the assessment year 2015 and 16, Lordship, the under section, Lordship, 148 of the Income Tax Act, the time expired on 31/3/2019, Lordship. But they have initiated this proceeding after the expiry of 3 years, that is 15/3/2022, Lordship, which is beyond a period of 3 years, Lordship. And Lordship.
Why do you say 3 years now, income tax act?
Lordship. Lordship, section 149, Lordship. Time limit for notice.
But if it is more than
50 lakhs, Lordship. But Lordship, that statement, Lordship, I have already annexed, Lordship. I have the Lordship at page At page lordship 33 and 34 lordship. They have lordship wrongly assessed lordship.
You will come, would you come under this act? This provision was only brought in 2021.
Yes, lordship. And the
Then
assessment was lordship in the year 2015-16 lordship of 2015-16 lordship.
Hmm.
And the time limits end in the year 2019 lordship. And lordship, they have assessed that I have some 60 lakhs deposit, fixed deposit. Lordship at page 32 lordship.
Hmm.
Sorry, lordship, page 31 lordship. And the second last lordship, column lordship, CIB 403 lordship, page 31. This is lordship SBI.
income has
Yes.
assessment amounting to rupees 78 lakhs.
Yes, lordship, but this one lordship, the second last column lordship, CIB 403 time deposit lordship. This thing lordship, State Bank of India Guwahati branch, they have said that there is a 60 lakhs fixed deposit lordship. Wherein lordship, page 34 lordship, the SBI has categorically stated lordship, they have certified lordship. Lordship, may I read lordship?
Hmm.
Lordship, this is to certify that Mr. So and so was maintaining the following fixed deposit accounts with our branch during the financial year 2014 and 15. As per our record, no other fixed deposit accounts were maintained during the financial year 2014-15. So this was the only two amounts, lordship, which amounts to rupees 30 lakhs. And lordship, the central bank 5 lakhs 50,000 lordship. That also they have given a statement, lordship, at page 33 lordship. The Central Bank of India lordship. Providing details, lordship, of fixed deposit opened during the financial year 2014-15 lordship, assessment year 15-16 of amount 60 lakhs and 5 lakhs 50. With reference to the above, it is hereby informed that you have not opened any fixed deposit during the financial year 2014-15, assessment year 2015-16 of an amount of 60 lakhs and 5 lakhs 50.
Now, have you replied?
Lordship, I have replied, lordship.
Where?
Lordship,
Where is your reply to the notice?
lordship will file at page 37, lordship. And lordship 36, sorry, lordship 36, lordship. This was lordship filed on lordship 17/8/2022 lordship. And lordship, thereafter they have issued another notice, lordship, which was 21/12/2022, and thereafter lordship, I approached this honorable court.
After this, what has happened?
Lordship, they have issued another notice, lordship.
Page 40.
Yes, lordship.
Then have you produced it? Where is your statement? You have already made that. Then why are you not producing it before that authority?
Lordship, I have placed all this, lordship.
Huh?
The bank details which I have placed, lordship.
Thereupon, they said notice under 142(1). 142(1) says what?
For an inquiry, lordship. Inquiry before assessment, lordship.
So this is a notice for inquiry. So
So now
why you are not submitting the documents which they have asked for? You have only replied. Then
Lordship, but unnecessary Lordship, they are harassing me, Lordship, because I do not have this amount, Lordship, as stated in my reply.
understood. So you submit those certificates before them. Furnish the information called for as per the annexure on the points of matter specified in so and so on demand. What are the points of, what are the annexures? Please justify why regular income of the year relevant to year. Why regular income was not filed. Please submit one bank statement of so and so and an aggregate quantum of so and so. Please also justify it since the address SSC had not disclosed the bank account to which an aggregate sum of rupees here was deposited during the final by so and so. Please justify why interest other than interest on securities of so and so was reported here. Please furnish the documents of the time deposit of so and so. Please furnish the documents relatable to the renewal of the time deposit made during so and so of rupees 1 in month and of rupees so and so. Please justify in absence of discharging the duty and obligation for filing a regular income via aggregate quantum here consisting of investment to so and so. You have sought for an adjournment and then approached this court. How is it possible?
Lordship, since Lordship, before the assessment, they should have inquired, Lordship, but they have already assessed and then they have taken steps for inquiry before assessment, Lordship.
They have the power to make a year. They say that there is an amount of 60 lakhs. You say that there is nothing out there. So you submit it by way of either verification. Yes, what is it?
Lordship, yeah, we have not filed our affidavit yet, Lordship. So we may be allowed 3 weeks time to file our affidavit, Lordship.
That has been pending since long.
2023.
What is wrong with you? Huh? What is wrong with the income tax department? If it takes so long to file an affidavit, what is wrong with you? Why you are not filing the affidavit?
Allow us further time, only 3 weeks time, Lordship.
1 week. If you don't file, we will presume that what he says is correct. It is seen that by an order dated 30/1/2023, this court had issued notice on a challenge being made to the proceedings initiated under Section 142 of the Income Tax Act 1961. This court further, by the said order, had stayed the notice dated 21/12/2022 and had stayed the further proceedings initiated by the Income Tax Department in respect to the notice under Section 142(1) dated 21/12/2022. It is further seen that the Income Tax Department thereafter has sought adjournment on various occasions, but till date, no affidavit has been filed. Today also, the counsel appearing on behalf of the Income Tax Department seeks for an accommodation. It seems that the Income Tax Department is not interested in the instant proceedings. Be that as it may, for the ends of justice, this court grants 2 weeks' time to file their reply. It is made clear that if the Income Tax Department fails to file their reply within this period, this court shall presume that the contents that the income tax department has accepted the contents made in the writ petition. This court fixes the matter again on 28th of August 2024. The affidavit be filed by the income tax department by 19th of August 2024. The petitioner, if so advised, would be at liberty to file the reply. On 28th of August, on the date so fixed, the income tax department shall also produce the records on the basis of which the reassessment proceedings have been initiated. Interim order passed earlier shall continue till the next date.
Highly obliged.
22.
So Lordship, kindly let it take on this Friday, my lord, I'll take instruction in the meantime, my lord, this Friday, my lord.
For what?
For release of security deposit.
This matter relates to release of security money.
Security deposit, my lord.
Work executed in 2015, madam.
25,68,809.
Yes.
Yes, why have you not released it?
My lord, later we take a day after tomorrow or Friday, my lord, I'll take the.
Matter was filed in the notice was issued long
Yes,
time
madam.
back.
Yes,
Then why you're not interested?
my lord, that's why, my lord, day after tomorrow or Friday, my lord, I'll give clear instruction on that, my lord. Friday or day after, any day, my lord.
The instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities to release the amount of rupees 25,68,809 to which the petitioner is entitled to upon successful completion of the contract. The said amount pertains to the amount retained on account of security deposit. It is seen that notice was issued as far back as on 2nd of 2023. Until date, no affidavit has been filed by the respondent authorities, neither any affidavit has been filed on behalf of the respondent authorities, nor any instructions provided as to why the amount has been withheld. For the ends of justice, this court grants an additional opportunity to the respondents to place before this court instructions by way of an affidavit as to why the amount has not yet been released. The respondents shall also apprise this court as to why interest as claimed in the writ petition should not be imposed upon the respondents. And if there is a fault on the part of an erring official as to why the same should not be deducted, or the ordered as to why the said interest should not be deducted from the salary of the erring official. List the matter again on 21st of August 2024. The affidavit be filed by 19th of August.
Okay.
Yes, Mr. B.P. Bora.
Is a matter where I mean evicted from government land without notice in exercise of the power of 18(2). Which house also dismantled.
You have been evicted?
Not from that part I've been evicted. House dismantled, part of the house dismantled. Photos at page 21 I have given. My FIR was also not registered. All the officials were there. The local MLA, the Lot Mondal, the sub-inspector. I went to the SP. SP also does not register my FIR.
Then?
Lordship, I moved whether there was an order from the DC or not. At page 29, I moved the RTI application. At page 27, Lordship would see the questions because there were two bulldozers. That at page 29, DC has also transferred my application. They have filed an affidavit saying that no notice is required as per 18(2). It is covered by your lordship judgment in Salahuddin notification.
Understood. But here is the thing which have already been affected. What to do?
But that's why I have prayed for compensation. Lordship,
Huh?
prayed for compensation
Compensation for what?
for the illegal act and arbitrary act of the respondent.
Now, if the land is at 296, then it's a roadside reservation land you cannot occupy. Neither you are entitled for settlement. Did you apply for settlement?
Yes, the possessory right I have taken over from
I'm not concerned with other things. Did you apply for settlement?
yes, Lordship Sasi
When?
Bhushan had applied at page 20 in the year 22
After the incident or before the incident?
for the incident. Lordship.
Where?
Lordship would see at page 34, Lordship. We are paying Khazana also. It is
No, it's okay.
applied by the person who was occupying from 1980.
34. Your application for settlement. What is the date?
It's to 15/12/2022.
1512. Your application for settlement of khas land and ceiling surplus land has been submitted successfully on Viman. Has been accepted. You may raise an appeal against that. Chalo. Then what happened? Which dark number did you ask for? 297.
Yes, Lordship, page 21, Lordship would see the dark number is mentioned at page
You have
20.
asked for only 297,
97.
not 296. Isn't it? Kindly come to page 35. Dark number detailed 297.
Yes, Lordship.
1 bigha. Where is the land?
As per them, it is
Is the land. As per them, it is not necessary. Where is the land is somewhere you will know also. Where is the land?
Nagari thing, Lordship. Some Nagari thing.
It is village land, not townlands. Is it townland or village land? Village. So village land, you are entitled to 1 bigha. Settlement, as per the land policy, how much?
I'm not sure about 2019
Oh.
policy. I'm not sure.
You file your application as per the 2019 policy and you are not sure. Where is the land policy?
2019 policy.
Sir, Bora. It be more ready. Why do you need the land? For
Or my house is residence,
homestead.
homestead.
And are you a TNT XT laborer? Are you? Do you have anything to do with that? No.
Not exclusive.
May be allotted with suitable homestead land not exceeding half a bigha. So you are entitled to half a bigha. Two katha 10 lectures. As per 3. Clause 3. Okay? Chalo. Yes, government, what do you have to say?
Already our detailed affidavit is dated the roadside land, reserved land. He has been paying the Bedokli Jorimanando.
Where he's been paying the dohoi.
33.
40. Page 43.
Huh?
31.
Where? Age?
30, he's referring to 30, I think. 30,
38.
3030. 30.
Where do you
I would look at state design.
This is a patta land. How does the government have any action on that? You have evicted him from 296.
290, 97.
Huh?
96. 296.
Then? Not 297.
297, the same is part of lots of paragraph 4. Eviction was carried out does not fall in the dark number 297, but the same is part of dark number 296, which is a land reserved for growth.
At page 22, I have given the photograph. At page 22, I have given the photograph of every what has done.
Okay, we do one thing. They say that 296 they have evicted you. But your application of 297 is still pending.
Not his application. The application of his vendor is pending.
Huh?
Yes.
From whom he has taken the
His
possessory right.
Page 34 is the application of his vendor.
Sasi Bhushan Singh.
Yes.
Yes.
And he is not a party before this court.
No.
No.
Page 18, Lord, make the
No, page 18, Lordship would see the agreement.
agreement of a subsequent time.
Page?
18,
Page
Lordship.
18.
Paper position.
I am staying here.
Mr. Counsel. His application is rightly to be dismissed on that ground itself. Once you are given a settlement, you cannot transfer it to anybody. And you, before application only, you did it. Can't help it. This was on 8th of December 2016. And the application is made by whom? In 2022? Not by you. No, the application is by whom? Sasi Bhushan.
Yes, Sasi Bhushan.
And who are you?
I am Kanai.
Then what business you have? And this is up for 297.
Different.
297. Then
I am saying the possessory right was transferred.
whatever may be, what right? Why didn't you apply? The division bench judgment makes it very clear two things. He is entitled to notice. But you have to have a bona fide claim of right. Why the notice is required? For the purpose of ascertaining as to whether you have a bona fide claim of right involved. To have a bona fide claim of right involved, you have to apply. Somebody else applies. What right you have, tell me? You don't have your own right. Why didn't you apply?
Yes, yes. Sorry.
Have you read my judgment?
Yes,
Totally.
yes, totally. I have tried it covers various concepts of legitimate expectation, natural justice, bona
Absolutely.
fide claim. And
Legitimate expectation is not a right. It gives you a right. Provided you have a right, then only you can have a legislative expectation. Now, you may have a legitimate expectation provided you apply. That you will be granted because of the policy. But when you have not applied, somebody else have applied for settlement. How do you have a right, tell me? How can you have a bona fide claim of right involved? In fact, your vendor should have filed this petition.
I had advised initially.
Then If he does not file, how do you come into? In fact, what the vendor does, he in fact violates by filing this requisition have violated the vendor's right. Because the vendor, if he gets it, he cannot. Just for example, your vendor has applied for 1 bigha. Okay. As per clause 3 of the land policy, you are only entitled to 2 katha 10 lechas. Now, these 10 katha 10 lechas have been given by your vendor to you. So, as per his application, he can't get more than 2 katha 10 lechas. And if he gets it, he cannot transfer for a particular period of time. So, isn't it everything what you have done is wrong? No case. I would have otherwise asked. If your vendor would have done, I could have gone. I directed them to consider the 297 application, but the vendor is not here.
But it will give 2 days time and
What are you going to do? Now, the vendor will come here. The vendor cannot come here. In this, you can't impede the vendor, na? Why don't you withdraw this petition and file it through a vendor? I think better off. Because if you do it, you will have no right.
get a prescription by
Better, that is the only way out.
Yes.
Because he may have some claim.
Yes. But what if, 10 minutes, Lordship will call this matter.
I think that is the only way out.
Yes.
Lordship. But just think about it, one thing, how to take care of that situation about the entering into agreement, would that affect the vendor? Otherwise, do you have your case, you have finished it, have you finished the case of the vendor also? Think about it. We'll have it on Wednesday. You just think about it. I think the vendor's case also has been destroyed by you by filing this petition.
An agreement.
Yeah, this agreement shouldn't have been, because by this agreement only you finish. Anyways, at the, upon hearing the learned counsel for the petitioner, Mr. P.P. Bora, the learned counsel, appearing on behalf of the petitioner, seeks some time to obtain certain instructions. Accordingly, the instant petition therefore stands adjourned to be listed again on 2nd of August. Take an instruction. 24.
May I please your lordship? May I please your lordship? Instruction not received, my lord. And
But this case, my lord, terms and condition of the agreement, my lord, has not been incorporated in the rate petition, my lord. There is a lapse on our part, my lord. So we need to file an additional affidavit, my lord, incorporating the terms and conditions, my lord. The issue is, my lord, that the bill that is being generated regarding the contract, they are not adding GST to that. The department is not.
PWD?
PWD.
You are PWD?
my lord.
And as per you, which clause of the agreement? 41? Which means everything is inclusive? Isn't it? To do. I delivered one judgment on this aspect of inclusion in view of section 62 of the Contract Act, Sale of Goods Act. Sale of Goods Act, yes. Wherein in 1962 there is a judgment of the Supreme Court, how it is. Anyway, Mr. B. Chakraborty, the learned counsel appearing on behalf of the petitioner, submits that he requires 2 weeks' time for filing a additional affidavit bringing on record the terms and conditions of the agreement entered into between the petitioner and the respondent, PWD. PWD, Accordingly, matters stand adjourned to be listed after 3 weeks. Who is appearing for Dimazo? What is your stand?
We have already filed our affidavit lodging.
Ah,
Here we have stated that that petitioner does not have any land of her own name, lordship. The land which she is claiming as it stands in the name of her father-in-law. And the compensation they have already received, lordship. Her husband has
to the
put
father-in-law.
in the name of her father-in-law, lordship. And they have already received the compensation. We have got the check number also, lordship.
Yes.
Romesh comply.
Romesh Kemprai. Yes, lordship. That has been clearly stated in the affidavit filed by the NHAI, lordship. We have got the check.
Kindly come to paragraph 7.
Our affidavit.
6. That the deputy deponent Beksu said that in pursuance to the secretary and the Lat Patwari had verified the land of the petitioner and it was found that the land in question still stands in the name of late Ramakanta Kemprai
Lordship.
and the same has not been transferred to anyone. The
Yes.
deponent Beksu said that the ground position of the said land falls within so and so alignment and the compensation of the said plot of land was already been received by one Romesh Kemprai. Who is he?
Romesh Kemprai is the husband of the petitioner, lordship, and is the son
Which
of.
was again claimed by so and so, wife of why one is Romesh and one is Ramesh?
Lordship, it should be Ramesh, R.A. It's a fact.
Both.
Yes, lordship. It's
Hello. And then
the Patwari report is also we have annexed, lordship.
none appears on behalf of the petitioner on call. Mr. R.M. Das
Lordship.
appears on behalf of the Dimahasa District Council. District Council?
Autonomous Council.
Autonomous Council. And Ms. So-and-so appears on behalf of the
That's one number 3, Lordship.
respondent number
3.
2 and 3.
Yes.
2 and 3. The petitioner herein have filed the instant writ petition claiming being agreed that no compensation was paid to the petitioner in respect to the acquisition so carried out by the NHIDCL. The NHIDCL had filed an affidavit stating that an amount of rupees 6,80,631 was deposited as compensation by check number 757847 payable to Sri Romesh Kemprai, the husband of the petitioner. It is also seen that the respondent Dimahasa Autonomous Council has also the respondent number 4 has also filed an affidavit in opposition stating inter alia that the amount of compensation in respect to the land covering AK Patta number 68, Dag number 18 have already been paid to Sri Romesh Kemprai, the husband of the petitioner. The fact that the husband of the petitioner having received the compensation in respect to the land in question is the stand which has been taken by the respondent authorities. The petitioner herein could not show any independent right to claim any part of that compensation. Be that as it may, the question as to whether the petitioner would have a right over that amount cannot be decided in the instant proceedings. Accordingly, taking into account the stand which has been taken by the respondent authorities, the instant petition, this court in a stand of the respondent, this court is of the opinion that this is not a fit case for exercising the jurisdiction under Article 2 to 6 of the Constitution. Be that as it may, if the petitioner is aggrieved at regarding non-receipt of any part of the compensation, the petitioner is always at liberty to approach the appropriate court in terms with Section 3H of the National Highways Act 1956. Petition stands disposed with the above observations and directions.
Okay.
26.
In the morning, my lord, I made a prayer for accommodation,
For what?
filing my lord responsible, affidavit in reply,
Huh?
filing reply, my lord.
Unfreezing your account. Your account has been freezed by?
My bank, respondent bank.
Not freezed, it has been marked with a lien. Since the husband of the writ petitioner has taken a loan and the writ petitioner herself was a guarantor to the loan facility. And in said connection, the lien was marked to the saving accounts, Your Lordship, since they have failed to make the payment. Section 171, Your Lordship, of Contract Act. They have not denied that they have not taken the loan.
My lord, loan was taken, my lord, in the year 2005, my lord, and my husband died in the year 2012. During his lifetime, my lord, he told that repayment has been made, my lord.
Who? You.
My husband.
He told it to you. Then?
And then, my lord, no action as such, my lord, from the bank was taken. When, my lord, I came before this honorable court in another round of litigation, then this matter was not disclosed in that petition, my lord. Now, after passing that order, when the bank having received the direction from this honorable court, now, my lord, they have taken this, this is afterthought. There is a
Bank
direction.
had already, there is a loan.
My husband took a loan, my lord, during his lifetime.
Did he repay it?
He told that.
No. On records. We have to assume, we are in a writ. We have to assume whether it has been repaid or not. If it is not repaid, you being a legal representative, you are liable to pay.
Lord,
You are the wife.
Lord, I am wife, and they are fighting.
Can they claim against you? Irrespective of whether you are a guarantor or not
I was a grantor, my lord.
of the
No
loan.
dispute of the loan.
So
So, my lord, my husband.
whether
was-
wouldn't it be coterminous? The demand, as regards liquidation of the loan, your liability, wouldn't it be coterminous with your husband?
That is right, my lord, but no action was taken. I was not, my lord,
You may say very well
had
that
told
the
you this,
interest could not have been done and everything.
my lord, NPA was declared on 31st March 2016, my lord. And it is barred by limitation, my lord. NPA was declared on 31st 3/2016.
There's a Reserve Bank circular, no? That within what time an NPA can be made? Can an NPA be made in respect to a stale? As per the agreement, can an NPA be made beyond a particular period of time?
I have to see, my lord, but if NPA was declared on 2016 March, my lord, then bank had a time, my lord, thereafter 3 years for taking legal action. Then 2019, up to 2019, they had time against me for recovery. Punishment.
Now what they have done?
Now, my lord,
Did they issue notice to you? Never.
No, your lordship.
no, no.
We have just intimate them that their account has been marked with a lien.
Why did you do it so late?
Your lordship, earlier this matter was pending in the WPC, so that the manager has not taken any action.
WPC.
That's
What-
some misappropriation of amount from the account, that is 7299 of 2016.
Then what happened?
And thereafter, when they approached for the, when the amount was credited in the saving account, they approached for refund of the money. So accordingly, we have put a lien on the accounts, your lordship. And that has been intimated after visit of the writ petitioner before the bank.
On the ground that she was a guarantor.
She was a correct.
But you have not taken any action against her. All
Your
this
lordship
while.
may not be required because it's a lien, your lordship, and the law is very settled that we may lose our remedy for filing a suit, but we may not lose against the recovery, your lordship.
But can you have a recovery? Anything? Can you make a recovery beyond a particular period of time?
Yes, 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 your lordship, in the lien we can.
Where is it so? What is this?
Your lordship, it starts from para 4, your lordship, that admittedly as the principal debtor did not repay the debt, the bank as a creditor adjusted the maturity of the FDR, the outstanding debt due to the bank in terms of the contract and the balance to the sum credited to the saving accounts of the respondent. The rule of limitation are not meant to destroy the rights of the party. And then the next page, your lordship.
Yes, Mr. Mullah, have you looked into the judgment of which court?
This is your lordship, Andhra Pradesh, and it has been reported in the year of 2007 SCC online, your lordship.
My lord, kindly see page 30, my lord. The earlier requisition, my lord, this is the affidavit filed by the bank. Paragraph number 3. Page 30, my lord.
Then
On the basis of this affidavit, my lord, your lordship was pleased to dispose of this order. My lord, kindly see page, it starts
Very
from page
good,
33 and then relevant, my lord, page 38, my lord. Paragraph 11, my lord.
Yes, Your Worship. It is only regarding the update of the amount. Yeah, yes, Your Honor.
and what happened?
And accordingly, we have updated the account, but since there was a loan, accordingly, we have put a lien on that.
In terms with this judgment.
Yes, sir. Your Lordship, a general lien, it can be applied in the banking sector, it's always, Your Lordship. Because if we have in possession of any money for any person, and if he has a loan, we have a right to set off against the loan account.
That is subject to the guarantee given.
Yes, that is subject to the guarantee. And guarantee has been executed and not denied by the writ petitioner.
What is does the guarantee permit exercise of the lien on her account?
Yes, Your Lordship.
Why will you brought on record the guarantee?
Yes, Your Lordship, I will file it by affidavit, Your Lordship.
Mr. M. Sharma, the learned counsel appearing on behalf of the HDFC Bank submits that he is going to file an additional affidavit bringing on record the agreement of guarantee, agreement of surety, so
Yes, sir.
submitted by the petitioner before the HDFC Bank. Into account that the agreement of surety is the basis on which the respondent HDFC Bank have exercised the lien over the amount lying in the savings account of the petitioner. This court grants 2 weeks' time to file the affidavit. This is the matter again on 30th of August 2024. Additional affidavit be filed by 19th of August.
Your Lordship, one more point is allowed, Your Lordship. that is section 171, if there is a contract contrary to that. But it says that general lien is there.
If you have no business with that, then how do you do it? There has to be something in relation to that. You cannot have a lien upon all everybody's accounts unless they.
Not everybody's account.
Therefore, it has to be there in that agreement of surety.
Yes, sir.
Agreement of surety, if it is so, then obviously you can. But otherwise, if there is no surety, agreement of surety, or does not conceive of anything of marking a lien on her account other, you can. Or
But,
because there is otherwise, there is always a provision that if you don't pay the loan, that loan can be very well recovered from the guarantor. Now,
It is
if it can
coextensive
be
language.
recovered from the guarantor, you can very well mark in view of the provisions of the contract act itself.
Yes, sir.
That can be done. So let's see.
All right.
None appeared on behalf of the petitioner on call. For the ends of justice, the matter stands adjourned. None appears on behalf of the respondent, petitioner as well as the respondent on call. For the ends of justice, the matter stands adjourned to be listed again on 4th of September 2024.
28.
Well, the issue in this litigation is very small, my lord. We have prayed for a direction to the circle officer to, my lord, conclusively determine, my lord, demarcation case, which is pending since 2018. And my lord, this honorable court director, my lord, wanted to know why it has not been finalized. There is an order on 5/6/2024 directing to obtain instruction. And then, my lord, an affidavit has also been filed by the, my lord, Deputy Commissioner, signed by the circle officer, where, my lord, the ground taken is that there is a title suit pending. And your worship knows that.
Yes, yes.
Yes, Lordship. So, what objection we have received, Lordship?
There are objections filed, my lord, letting determine, my lord, the objection. There is no question of keeping the matter pending. In fact, my lord, your worship has earlier passed an order in another case where, my lord, there was a restraint order also, injunction order. Even then, your worship directed that, my lord, the matter should be finalized. I place that order, my lord.
There is a difference between partition and demarcation. A demarcation proceedings is to find out what is the area.
Lordship.
Partition is a proceedings by which a person may very well ask that I want this land in my place, or take out my land from that entire dark, where there might be a dispute for which you may very well refer it to the civil court. But where is the scope for demarcation? Go ahead with the demarcation. Don't, you only have to show which is the area. Matter ends there. And thereupon don't disturb the possession of any of the party. Just find out the demarcation and show it. And submit a report and give it to the matter ends there.
That's
Isn't
our
that?
only prayer. Let him determine it.
What is there? Who are you?
For respondent number 5.
You should not have any objection. Possession would not be disturbed. Possession remains as it is. They will just demarcate and submit a report. That I understand. The heard Mr. M.K. Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner, Mr. N. Goswami.
2, 3 and 4.
Appears on behalf of the respondent numbers 2, 3, and 4. Ms. So and so appears on behalf of the respondent number 5. And revenue, no revenue business. None appears on behalf of the revenue department when the matter has been called. Mr. Hendrick. Mr. J.C. Hendrick appears on behalf of the revenue department. The petitioner is aggrieved by the inaction on the part of the respondent numbers 2, 3, and 4 in disposing of the demarcation case number 382/2017-18, whereby the petitioner have sought for demarcating his boundaries of 2 Katha 5.22 lessors covered by DAG number 850 included in KP Patta number 592 under Ulubari Moja village, Sohor, Guwahati, part number 7. This court have duly taken note of that notice was issued by this court on 13/10/2023, and an observation also have been made in the said order that there is an objection which was filed by the respondent number 5. And it was on account of that the demarcation proceedings have not been disposed of. This court also takes note of an affidavit have been filed by the respondent number 2, 3, 4 and 2, 3, and 4, wherein it has been mentioned that there is a civil litigation pending between the petitioner and the respondent number 5. Today, Mr. N. Goswami, the learned counsel, appearing on behalf of the respondent numbers 2 to 4, 4 submitted on instructions that the demarcation proceedings was stopped on account of an objection being filed by the respondent number 5 in view of the pendency of title suit number 326/2019. This court have also perused the objection which was filed as the same was made a part of the instruction which was submitted by Mr. N. Goswami. The instructions, the objection stipulates that the objection is based upon section 100 of the Assam Land and Revenue Regulations 1886. This court have duly perused the provisions of section 100 of the regulations of 1886. The said provision is in respect to a partition whereby wherein it is stipulated that if there is a dispute as regards the title over the property in question, the revenue authorities should direct the parties to approach the civil court and get a decree in that regard. In the instant case, however, the issue involved is not as regards partition, but as regards demarcation, whereby the petitioner have sought that the land measuring 2 kathas 5.22 lessers covered by dag number 850 included in KP Patta number 592 under Moza Ulubari, village Sohor Guwahati, part 7, be demarcated. Under such circumstances, this court is of the opinion that the revenue authorities can very well go ahead with the demarcation. However, in doing so, shall not disturb the possession of either of the parties, taking into account there is a civil proceedings pending. Accordingly, this court therefore directs the circle officer. Which circle officer? Guwahati Revenue Circle, that is the respondent number 4, to carry out the demarcation as regards the plot of land measuring 2 katha 5.22 lessers belonging to the petitioner, lessers, covered by dag number 850 and included in KP Patta number 592 under Ulubari Moja, village Sohor Guwahati, part 7. By giving proper notice to the boundary, to the persons in the boundary of the said plot of land, and thereupon show the respective boundaries of the said plot of land. It is made clear that the possession of none of the parties should be disturbed on the basis of the said demarcation proceedings. With the above, the petition stands disposed. This court further, on the basis of the said demarcation so carried out, the respondent number 4 shall also prepare a minute and duly circulate with the petitioner as well as the respondent number 5. With the above, the instant petition stands disposed.
Time limit or expeditious or
The
something.
said exercise be completed within 3 months from the date a certified copy of the instant order is served upon the respondent of the
29.
May I please, Your Lordship? In this case, Your Lordship, petitioner husband had expired due to hit by unknown vehicle. And-
What?
And,
Accidental death of one Rutin Chandra Burman.
yes, Lord,
How did he die?
hit by unknown vehicle, Your Lordship. Hit by unknown vehicle, Your Lordship.
Unknown vehicle.
Yes, Lordship. And, so far as my concern.
Final report? Why?
We have not exactly. And,
This is under the officer in charge, respondent number 6. Mr. N. Goswami, kindly get that as to whether the final report have been submitted.
We have filed a charge sheet, Lordship.
Huh?
Charge sheet has been filed, Lordship.
Okay, charge sheet. What is the,
Lordship.
what has been mentioned in the charge sheet? Who has committed the mistake?
That was not mentioned, Lordship.
Huh?
That was not mentioned in my instruction, Lordship. But it's unknown motorcycle, Lordship.
Motorcycle is unknown.
Lordship. An unknown motorcycle coming from Lordship, yes, unknown.
The instant petition has heard Mr. S.K. Akan, S.I. Akan, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent number 3 to 6. Mr. A. Bhattacharjee appears for respondent number 1. None appears on behalf of the respondent number 2. The petitioner herein is aggrieved.
May I submit, Lordship?
Yes.
May I bring the original charge sheet, Lordship, because some case was registered, Lordship.
sheet is filed, maybe some against some person. It may be against some other person, some person.
Okay, ठीक है. Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 226, 2269, for 326 is directed to place before this court the charge sheet so submitted in respect to
Bogri police case number 38 of 22.
Bagribari BAGRI, Bagribari PS case number 38/2022. He said obtain categorical information as to whether the vehicle by which the petitioner's husband met with the accident and succumbed to the said accident have been identified or not.
After
List the matter again on 19th of August 2024. Yes, Mr. Vanik. Anything to do with fishery? No.
society.
Anything to do with fishery. Now this is with cooperative society.
One of the
Now what has the cooperative society done to you?
Mohanpur Samabai Samiti Limited of Hailakandi.
What are you challenging?
Was challenging an order at page 51 by which the Register of Cooperative Societies has cancelled the election. But in just what has happened is, and I'm quite sure the respondents would not address on this issue.
Election was held
They are not on the election.
and they cancelled it.
They have cancelled it.
Why?
What I'm on is that when the nominations were there, 27 in all, 9 were accepted, 12 rejected, cancelled, and 6 withdrawn. Withdrawn are gone. Now, the 9 which were accepted, are uncontested. Now, those out of 12, they approach the registrar. They are not against us. They say, since it's a requirement that the previous 5 years you have to attend at least 2 meetings, in their cases, all have not opposed, 5 have opposed. They say, for a particular 2 years, admitted, we also do not dispute that the proceeding books were missing. Proceeding books were missing for 2 years. So therefore, whether or not they attended the meeting could not be properly asserted. This found favor with the jurisdictional registrar and he cancelled the entire elections. Next year. Nominations having been declared valid and even otherwise out of 15 plus 9 are there. 7 of us here, but 2 would be more. We would be declared uncontested. There would be no question of elections and nominations were not even challenged by anyone. It's nobody's case. Even theirs, not even their case. They say, so far as their rejection is concerned, proceeding being not there, the rejection is bad in law. Now, on that score, the Honorable Single Judge in the motion states below, state that part of the order whereby fresh elections were declared. So we say, so far as we are there, we'll go ahead and form the board. So far as the rest is concerned, if my lord holds that the rejection is bad in law, then consequences to follow. If it is not bad in law, then to follow. But so far as the 9 who have sailed through en bloc, that may not be the correct proposition of law.
Yes, Corporation Department. Has the Corporation Department ceded its place to Mr. Kadir?
And for the private respondent. One nomination was cancelled.
Huh?
One nomination was cancelled, my lord.
Understood.
In violation of 42.
But after all, you are a private respondent.
Yes, I will address.
Person who have committed the alleged illegality as per Mr. Pudding
Okay.
is taking the back seat. have not filed any affidavit, does not think that an affidavit is required. So should we accept what Mr. Bonik says?
No, my lord, I am the
Is
interim
it
order
because
is
of
here.
you saying on a provision of law, or is it on the basis of facts? If it is on the basis of facts, why there is no affidavit? If it is on the provision of law, not necessary to file an affidavit.
Yes, well, facts are more or less admitted. There is no dispute.
Then we go as per the law.
Yes, sir.
Okay.
So in fact, my lord, at which starts from page 51, the operative part is at page 52. The reasoning of the register, why, my lord, it has been cancelled. Page 52.
Okay.
My lord, register says, the lordship has got it 52. In the absence of the original proceeding book and attendance register of 2021, 21-22, it cannot be ascertained whether the Xerox copy of the attendance register available with the petitioner is correct. Petitioner means, my lord, those the applicants, here the private respondents, or the attendance register available in office is correct. Because it is seen that some serial number in the attendance register present with the office are blank, whereas in some serial number has the name of the petitioner in the Xerox copy of the attendance register available with the petitioner. It is not possible to ascertain whether without the original attendance register, whether the said serial numbers were originally blank or were erased off while making a photocopy. As the petitioners were otherwise eligible to be elected as BOD of Mohanpur CS Limited under section 37 and 40, except for violation of 40 subsection 2. This is, my lord, where the requirement comes in, 42. At least 2 AGM. Attendance of 2, my lord, last AGM for the last 5 years. The violation of which could not be substantiated in the wake of the absence of original attendance register. The right of the petitioners to be members of the board cannot be curtailed. So this is, my lord, the reasoning. The register says, my lord, they had the right to participate in the election, my lord. And therefore, the entire election, my lord, has been set aside. This is the ground for enabling them to participate in the election, my lord, the private respondents.
He must add on one thing, that the entire gamut of the allegation is cancellation of 5 nominations. May I read the first paragraph?
No. First of all, do you have the original or not?
No. We say, regardless of the 2, we are okay because all the 5 things we are there. Meetings, we were there. There were no difficulty with us. What I am trying to persuade your lordship on into is that page 51 it says, if I read page 51 for a moment, it says of 5 cancellations.
So did you hold those 5 every year you have to hold the AGM?
No, we are the fresh ones who have participated in the election. Our nominations were scrutinized, subject to objection. Nothing came through. The nominations were scrutinized and declared to be valid. Now it was a total number of 15 posts of board of directors. 7 with petitioners are there, plus 2, 9 are valid. Now the allegation is that although 12 were cancelled, 5 of them, only 5, not 12, 5 are wrong because for 2 years the proceeding book is not there. We have made a statement. You did not challenge for us, and even then it's a matter of record. Even without those 2, we are there in the earlier 3 also. So we are through. The only thing is false is that.
Now who cancels it?
It's by way of an application under Rule 27, if lordship sees. From the declaration results within 3 days of the election rules, it says any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of results before the election authority, that's the registrar. The election authority shall make an inquiry upon the dispute on the basis of the relevant records and pass necessary orders. We say, correct. We challenged it on one count that 2 were not there. And page 51 talks about cancellation of 5 nominations. Not more. Assuming, but not admitting, you sail through. So 9 plus 5 is 14. So 14 does not require election. Even if they come in, it would be uncontested. That was what fell through. That was the thinking fell
So
through.
your long and short submission is that these are the 5 people who are aggrieved.
Yes.
And if their nomination is not cancelled also, they may very well be brought in. These people, they should have filed their application or election dispute out there. And that the registrar can very well decide inter se only in respect to their cancellation and has nothing to do as regards the entire election. Or in other words, if the Lok Sabha elections is held, in Assam there is some gross problems, for that you don't cancel the entire Lok Sabha elections, but hold election petitions in the Guwahati High Court as regards the 14. That's your submission.
And rule 13, if Lordship will take for a consideration.
Mr. Talukdar, he makes it very simple.
That is a valid argument, madam, but here the registrar has assigned the reasons, madam.
Understood. But could he have cancelled, just for, let us take a hypothetical situation. One person was illegally rejected. He files a election petition. You cancel the election, the entire election process, or only set aside him and hold the fresh elections as regards him. That is his submission.
Here, my lord, this 5 cancellation.
Understood. If it was the case, there were 30 people who have been rejected. Then the question would have been, those people would have been. But here only 5 persons are aggrieved. If these 5 persons are given also,
yes,
then also it would not disturb them because otherwise it is total is 15. So then also it becomes 14. So is it necessary for the election they have to cancel the set aside? Because this has a lot of consequences. The moment you are cancelling this, it will require a lot of other attendance and all. What do you do if a person have been invalidly rejected by the year? Then do you hold a fresh election for them? How do you fill up if there is a vacancy?
Yes, my lord, in fact, there is a provision under 43, my lord, 41, 41(9). 41(9).
Where there are vacancies in the office of the and where there are no sufficient number of years to constitute, the board may co-opt maximum 3 eligible persons for continuing the co-op or arrange for holding
Or
election.
arrange for holding elections.
So that could have been
to
done.
fill up the vacancies. That can be done.
Then why should
we
it
hold
be?
the elections? We'll come in now.
So that will be held if it is so. He should not have rejected the entire thing.
Only for the remaining. Now. They will remain, 9 will remain, and in respect of the other 6, my lord, election will be held in terms of 41(9).
It was not necessary to cancel the entire thing because it will have a far-reaching consequences.
That will strike the balance. My lord.
And not only that, it may affect also that not doing the entire board will go. Yes. 37, na?
39.
So the board will go not holding the AGM within time.
39.
39.
The board gets the benefit of these months.
Yes, now let us hear Mr. Kadir. His name has been wrongly typed by everybody.
Yes.
Alexa G, they have put it Kusili.
Even in the order, it's there that way. He was
Yes,
there.
Mr. Kadir. Your name has been wrongly typed out Kusili or something.
Page 54 also that way only.
Huh?
He was there before the registrar.
Yes,
As I
that is
gather.
what, na. His name has been wrongly mentioned.
Pronunciation usually is also means an advocate, madam. I think definitely. usually, some
There's an advocate.
meaning advocates. So I think
Is,
this typing,
is this you or no?
it is typing error, my lord. It is
This
typing.
is you.
Yes, sir. I was there. My lord, the cancellation sheet is annexed, my friend, my lord, in the writ petition, my lord. Where, my lord, these 10 respondents' name is there, my lord. So these 10 respondents, by 10 to 19, my lord, their nominations cancelled, my lord.
How many?
As per 40, 10, my lord. 10, my lord. 10 to 19 of the respondents, my lord. I represent, my lord.
All of them have been cancelled.
Yes, my lord. Page number 27, my lord, the cancellation sheet is annexed, my lord, with the writ petition, my lord. From page number 26 onwards, my lord. Page 26 onwards, my lord.
6 onwards.
Serial number 8 is the respondent number 19, my lord. Respondent number 12 is 10, my lord. Serial number 10. Next, my lord, page number 28.
No,
Serial
no,
number-
no, no, no. See, we are concerned with the rejection. What is the reason for rejection?
Rejection is, my lord, that we have not attended 2 of the meetings out of the 5.
Who are the persons who have not? Whose rejection has happened on account of not attending the meetings? 2 meetings.
Our, my lord. This
Our means
10
which?
to 19, my lord. Respondent number 10 to
No, there are 2 withdrawal.
No, my lord. No, my lord. Serial number 8, 8 and 10 in page number 26, my lord.
What about 6 and 8? 6 and 9?
They are not the respondents, my lord.
Okay. And C is what?
C is cancel, my lord.
Cancel. And others are A to all A are
Accepted, my lord. Accepted.
accepted. So whose have been rejected?
What is submitting?
8
is
and 10,
submitted.
my
5 were aggrieved. 10 were 12 were cancelled. 5 were aggrieved. Rest waived. Rest they waived it. These 5 is under page 51.
Who filed the election petition?
My lord, we 10. This is number 10 to 19, my lord.
Where is it? Where is your election petition?
Election petition not annexed, my lord, in the order mentioned, my lord.
No, no,
Page
no. Where is
number-
your election petition?
My lord, page number 51, my lord.
51.
51, my lord, it is mentioned that the Nurul Haq and 9 others, these are the private respondents, my lord. Nurul Haq and 9 others, the present respondents, my lord. That's one number 10 to 19. my lord.
LH cancellation of 5 numbers.
No, no. We are the who are the where is your election petition?
An election petition not annexed, my lord.
Huh?
But this is mentioned, my lord, the Nurul Haq and 9 others, my lord. These are, my lord, this one number 10 to 19, my lord.
No, no. Wait. Unless we see that, we cannot hold it because he says something else.
The page 51, Lordship may see for a moment. If I
Page-
may read
page-
4 lines of that.
Page 51 also mentioned, my lord, that the Nurul Haq is the respondent number 10, my lord. And 9 others, my
No,
lord.
we are not concerned with other withdrawals. We are not. Those people who have filed the election petition
Yes, my
only
lord.
on the ground,
Yes, my lord.
and their rejection has to be only on the ground of that photocopy.
Yes, my lord. It is
Because the photocopy, whether it has been erased or not, whether it is in respect of all or so and so. Mr. Talukdar, I think this is a thing which needs a clarification to that effect. If it is a case of 10, it's a different aspect of the matter. But if it is only, therefore the election petition would be relevant.
My lord, what it says, the third line, page 51.
Hmm.
And the alleged illegal cancellation of nomination, 5 number of applicants.
5.
So it is only 5.
5. It is mentioned here.
So if it is only 5 and that is the reason why it has been done, then what is there? Why should it be a new one? Elections will be held. They will consider you, not not a bar of those 5. Who are the 5?
He will know, my lord.
That is the problem.
My lord, 5, my lord, I have mentioned from, my lord, 10 to 19, my lord.
No, no, no. Who are the 5? Therefore,
Oh,
let us have the election petition.
5, my lord, we do not
Mr.
know
Kadir,
from-
produce your election petition.
I will, my lord, file by an affidavit, my lord.
Huh?
I will file by an affidavit, my lord.
You have not filed?
Affidavit filed, my lord, but it is not annexed, my lord. Election petition.
Bring on record that application wherein it shows that 5. And Mr. Talukdar, you get your information only to who are the 5.
My lord.
Because then I will permit these 5 to contest without a problem with 42.
My lord.
And then
Document
hold the
recorded.
election.
Yes.
That is
I'll
a
take that
small issue.
Correct.
Yeah. Heard Mr. S. Bunik, the learned counsel appearing on behalf of the petitioner, Mr. S. K. Talukdar, the learned counsel appearing on behalf of the Corporation Department, and Mr. M. J. Kadir, the learned counsel, Kadir Qadir. The learned counsel appearing on behalf of the private respondents. The instant writ petition has been filed by the petitioner challenging the order dated 6/10/2023, whereby the Register of Cooperative Society have cancelled the entire election which was held in the AGM on 25/4/2023. Mr. S. Bunik, the learned counsel appearing on behalf of the petitioner, drawing the attention of this court to the order dated 6/10/2023, submitted that there is no quarrel with the proposition, that there is no dispute to the effect that the petitioners herein, who are 9 in number, and the petitioner who are 7, and along with another 2, have been duly elected uncontested. Referring to section, which one for 15 it should be?
It was for 15, the notice.
Yeah, where it says that it should be 15.
My lord, it's Lordship finds at page 23.
Referring to the bylaws.
Notice, the notice itself, page 23 for election.
No, it has to be in the bylaw somewhere, because otherwise the maximum is 30, it will 20.
It's here, the notice said for 15.
Huh?
35, section 35 of this act, my lord. This would say, 35 would say the maximum is 21, maximum. But the notice was for 15.
Where?
Page 23.
23.
When did go?
Referring to the notice dated.
Lordship, this is dated.
Referring to the notice enclosed as Annexure B.
30th of January. 30th of January.
2023. 30th of January 2023, enclosed as Annexure B to the writ petition, the learned counsel for the petitioner submitted that the total number of directors who were to be elected were 15. The only 5 of the private respondents and five shareholders being aggrieved by their cancellation in view of section 40(2) of the Assam Cooperative Society Act 2007 have filed election proceedings.
10 have filed, agitating cause of 5.
The learned counsel further submitted that against the rejection of 5 shareholders in view of section 40(2) of the Assam Cooperative Society Act 2007, and election proceedings were initiated before the Register of Cooperative Society. The Register of Cooperative Society, as per the learned counsel appearing on behalf of the petitioner, could have held that had the jurisdiction to hold that the rejection of the candidature of those shareholders were in accordance with law, accordance with the provisions of the Act of 2007 or not. And accordingly, but would not have nullified the entire election proceedings. Referring to section 41(9) of the Act of 2007, the learned counsel for the petitioner further submitted that if there is a vacancy, the same could be filled up in terms with the said provision. But the register of the cooperative society committed illegality in nullifying the entire election. Mr. S. This court have given due consideration to the said submissions, and taking into account that it is not clear from the materials before this court as to who were the 5 shareholders whose candidates were rejected in view of section 40(2) of the Act of 2007, this court is of the opinion that a perusal of the election petition so filed would be relevant for a proper adjudication of the instant dispute. Accordingly, so Mr. M.J. Kadir, the learned counsel, appearing on behalf of the private respondents who had filed the said election proceedings, is directed to bring on record by way of an additional affidavit the election petition which was submitted before the Register of Cooperative Society. Mr. S.K. Talukdar, the learned counsel, appearing on behalf of the Corporation Department, shall also get instruction as to who were the 5 shareholders whose candidates were rejected in terms with section 40(2) of the Act of 2007. List the matter on 19th of August 2024 for further consideration. Interim order is there?
My lord, since September 30th is approaching and time period for notices would also be there, may I pray all humility for a prior listing, my lord? Because September 30th deadline has to be met in the event we come in. Because that requirement 39 would otherwise
Okay, 12th of August. 12th of August. You get just the information, who were the 5. If he doesn't file also, we can take it over.
the interim protection.
The interim order passed earlier shall continue to.
So, my lord, I will file the affidavit immediately, my lord. If the record is, my lord, from the register office, my lord.
Have asked him.
Yeah,
And when I have said further consideration, Mr. Talukdar understands what to do.
Yes, very good. Also, the short point involved over here is that in the application for cancellation of registration of the GST, and inadvertently, the date of cancellation was mentioned as year 2020. It ought to have been 2021. For the reason, I filed my return till 2021. For that reason, I made an application before the authorities that this date has to be
Cancellation of the registration dated so and so, and upon being pleased to correct the effective date of cancellation of the registration which was inadvertently written here by instead of the correct date as 1/8. You want as per 1/8/2021, not 1/8/2020. Yes, what is it?
Lordship, may pass order to rectify the dates, Lordship. We have received instruction, Lordship. Lordship may pass order, Lordship, to rectify the incorrect dates, Lordship.
So,
Our instruction.
I will presume that you will be rectifying it.
Yes, Lordship.
Heard Mr. H. Petala, the learned counsel, appearing on behalf of the petitioner, Mr. S.C. Ms. So-and-so,
M. Deka.
appearing on behalf of the GST, and Mr. B. Chaudhary, appearing on behalf of the Finance and Taxation Department of the Government of Assam. The instant writ petition has been filed on a very limited score, in as much as the petitioner herein is aggrieved at the inaction on the part of the respondent authorities in not making due correction to the effective date of cancellation of the certificate of registration.
Page 43 is the annexure.
The Mr. H. Petala, the learned counsel, appearing on behalf of the petitioner, submitted that the effective date for cancellation of the registration should have been 1/8/2021 and not 1/8/2020, taking into account that the petitioner have duly submitted its return till then. Ms. M. Deka, appearing on behalf of the GST, submits that the respondent authorities, more particularly the respondent numbers 2 and 3, are not adverse to making the correction in pursuance to the representation so submitted by the petitioner on 9/3/2023. So taking into account the said submission made by the learned counsel appearing on behalf of the respondent number 2 and 3, this court disposes of the instant writ petition, thereby directing the respondent number 2 and 3 to make necessary correction to the certificate, the cancellation of the certificate of registration of the petitioner in terms with the representations dated 9/3/2023. With the above, the instant petition stands disposed.
Highly obvious.
Yes. Yeah, what is this? Guys, be lost call.
Yeah.
What have you done with these forest
Lordship,
people?
we have submitted instruction where we have stated there is no program for evicting them, Lordship. They are contemplating, we will evict them from the land, Lordship. I got records, marks annexure X, Lordship.
Lecture X.
X.
There is no program for eviction or encroachment of Dolkasa extension forest areas which falls in Iman under Iman. Who are you?
Well, we have forest villages, Tangia forest villages.
Forest dwellers.
There is a system, my lordship, Tangia forest village dwellers.
You are forest villagers.
I can, page 36 may be seen, my lordship, page 36.
Page 36.
The type copy, page 37 is the.
Please find here with a petition by the N39 paying for land of the Iman. It seems that the applicant seems was evicted twice, but there has been no place for them to go and they are being landless. And accommodate them as Tangya village and allow them to come. Then what happened?
Page 40 may be seen, my lord.
Huh?
Page 40. Annexure 3, page 40 may be.
41.
40 is the type copy and 41 is the original.
Bearer of these letters, so and others were evicted from reserve forest on Sri Vibhachi. Who is this M.A. Islam? Then what happened?
My lordship, since then, my lordship, we are allowed to settle as Tangia forest villagers. Tangia forest villagers, we were allowed to cultivate on the land which we have cleared. My lordship. The definition of Tangia forest villager, para, my lordship, para 3 of the writ petition I have stated, my lord.
Okay, but whatever, okay, they are not to be evicted is another thing. But what are you going to do as regards their prayer for settlement?
Yes.
For settlement and lordship, since they have the whatever land belongs to the forest, it belongs to the forest. If they want some land, they want a settlement of land, they have to approach the government for the as per land policy, lordship.
No. Mr. Counsel, no, nothing doing. Kindly see the Assam Land and Revenue Regulation. C6. We have the Assam Land and Revenue Regulation. Then, as forest lands do not fall within the ambit of the land policy. That land policy is under the Assam Land and Revenue Regulation. And 6 says categorically that that is out. So it is you who have to do. The government of Assam will do it, but the forest department is to do it. And this will be done as per that schedule, dwellers or all these things. There's a provision of the, how do you do it? How do you protect? They have to file applications to that effect. They cannot be given in respect of reserve forest.
Yes,
They may get under the village forest. That is under the chapter 4 or 5 of the Assam
Chapter
Forest
7.
Regulation.
Chapter 7.
Huh?
Chapter 7. I had to-
Yes. Then you file your affidavit. What you are doing with all these people? They're different thing. They are not going to be evicted. But what do you do? We are not concerned with not to evict, but what do you do? Write a manual directing here to complete the process of settling of land, because from 1976, they are holding it. Make an inquiry, file your affidavit. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that he requires 4 weeks' time to file an affidavit. Full stop. The Forest Department, with the taking into account the above, this court fixes the matter again on 9th of September 2024. The affidavit be filed by 30th of August 2024. Full stop. It is made in the said affidavit to be filed by the Forest Department. The Forest Department shall also indicate as to whether the applications so filed by the petitioners have been considered for settlement in terms with the applicable provisions of law. Is there interim order?
Interim order is there.
It has also been submitted by Mr. Anabutha. In addition to that, this court also takes note of an instruction which was placed before this court, wherein it has been mentioned that there is no move on the part of the respondent authorities to evict the petitioners. Taking into account the above, there is no move on the part of the respondent authorities for eviction or encroach for eviction. At the Dolsera Extension Forest areas, which falls in ILRF of Matizuri Range under Hailakandi Forest Division. So taking into account the above, this court extends the interim order which was passed till the disposal of the petition.
Obliged. Highly obliged.
But here, Malad, against the order, we have prepared a review petition, Malad. The review petition is numbered and notice was issued on 26/4/24, Malad. Malad, I pray for taking up this matter along with the Malad, we have prepared a review petition against the order, which is alleged to have been violated, Malad. Notice was issued on 26/4/24, Malad. In the review petition, Malad.
What is the order passed?
The order passed is to release the land acquisition compensation amount, Malad, in respect of kindly come to page number 35, Malad, the operative portion. That being the position, the respondent number 4, Deputy Commissioner Kamrup Metro, is directed to pay due compensation to the petitioner for acquisition of 3 vega 15 lessas of land covered by DAG number so and so, pata number so and so, Ulubari Moja.
Then what happened?
But after that, Malad, they subsequently they got the records and the Javamandi Sadar Javamandi copy, wherefrom Malad, in the Sadar Javamandi copy reveals that during lifetime of the patadars, they sold so many plots of land to different patadars. And after that, if that is considered, Malad, the remaining land only 4 kata 15 lecha, 4 kata 15 lecha is left with the original patadar, who is the petitioner in this case. That could not be brought before your lordship at that time when the petition was considered, because a record was not produced and it was not placed. But when the Sadar Javamandi copy was revealed, accordingly we have preferred the review petition to bringing up it on record.
The 4 kata 15 lessas.
4 kata 15 lessa, in our affidavit in opposition, we have stated that as regard the 4 kata 15 lessa land, we have already calculated and they were requested to accept the amount. They have it was offered to them. They have not accepted.
Why are you not accepting?
The land measuring 3 bigha.
Understood. Mr. Counsel, this is done under the old act. This is under the old act.
Under old act.
Council, why you're not understanding? You can very well take it under protest. You can file two reference, one reference on the entire amount and whatever if you are agreed by the compensation amount. There are two aspects. One is as regards apportionment and one is as regards the payment. How much you are entitled. If you are entitled to, if you say that okay, the amount is less, means the value of the land has been given less, you can very well ask for. And other is and file a reference case. And they will also, and as regards if you are entitled for the entire land, 3 bighas, you ask for that. But if you don't do it, if you don't accept it, who's lost? Because the interest will not accrue on that. At the end of the day, you will be losing. Get the point?
Let it be taken after today's.
You will be losing. The problem therefore arises here in these type of matters with this direction is that because this is not the duty of the RIP to decide how much unless you duly accept, unless you accept that yes, this land is in his name. But there are somebody else who are there. There will be other people who will be making a claim. We do one thing. We take this with the review. The learned counsel appearing on behalf of the petitioner seeks for some accommodation. Mr. Dina, the learned counsel appearing on behalf of the respondents submits that in respect to the judgment and order passed by this court. But this can be an order of 2024, which order?
Well, in the order, it is wrongly reflected. 28/1/2019 ought to be there, Malon. The contempt is against 28/1/2019. It is
Has
wrongly.
been also
it is wrongly
Mr.
typed.
Dina, the learned counsel appearing on behalf of the respondent submits that against the order dated 28/1/2019 passed in WPC number 4507/2013 and review application has been filed. And wherein notice have been issued on 26/4/2024. Who list this matter on 19th of August 2024 along with the review petition number 45/2024.
Six.
Lord, the order passed by the Sonopur court that was not complied by the Lord Deputy Commissioner, Lordship will find at page 8. And Lord, the operative part, page 10. Last, Lord, 3 bra.
What is the direction?
Direction part, Lordship will find page 10.
In view of the above, without expression on the merits of the case projected, even so far as the claim of the over the landing and the region disposed of by providing it may examine the representations by the petitioner and take appropriate action in the matter as may be done. If on verification it transpires that the issue. Then nothing was done. So for which you filed this review. Yes, government, who is appearing? On behalf of the District Commissioner, Kokrajhar, anybody? Huh? What?
Is reflected on the cause list, Lordship. Name of MS Udas, additional government advocate. Her name was reflected in the cause list, Lordship.
She is not there, so
Yes.
you want this person to be sent to jail? We accept
No,
it.
Lordship.
We'll take it as if Mr. Burwa submits that he should be sent
No,
to
no.
jail. We send him to jail. Hello? None appears on behalf of the contemners on call. What?
I am informing him, her Lordship.
Then? When is she coming?
Let it
Ask
be,
her to come or we send her to jail. Ask this person to be personally present.
On, brief is not with me also,
I
Lordship.
can't help it. None appears. There's somebody who has filed an affidavit. Pradeep Kumar Dwivedi. I am the District Commissioner, Kokrajhar, Assam. Has filed an affidavit on 23/2024.
Kindly take it to some after.
So
some
we'll
time.
ask them to send to personal, none appears, so we'll do it. Ask her to be present or whoever it is.
Yes,
Else
Lordship,
we
I
are going to ask this
inform.
person to be, this is a contempt matter,
Yes, Lordship.
not to be taken up so easily. Ask whoever it is to come.
37.
From the office note dated 24/7/2024, it is seen that the service upon the respondent number 4 is complete. Taking into account the above, the matter be listed before the listed for admission. By the registrar.
Within 38, my lord, to enter as appearance in this case, Lordship. I need some time, Lordship.
What is this? 2 lakhs,
2 lakhs.
1511. Okay, then
My lord, what are my lord, starting from page 11, my lord? Operative part, my lord, page 13, paragraph 5 and 6.
so what is your instruction? Are you appearing for anybody?
Lordship, for respond number 1, Lord.
1.
One.
What about 2?
To my lord, I already,
My lord, regarding Flax Acts is mentioned, my lord,
I already been talked with them on some officials, my lord. They will send them, my lord, that,
Get your instruction.
Lordship.
Get your instruction in why it has not been complied with. Mr. J.C. Hendig, appearing on behalf of the respondent numbers 1 and 2, submits is directed to obtain instructions as to why the order dated 16/11/2022 passed in WPC number 4804/2022 has not yet been complied with.
Lordship, my lord, Deputy Commissioner already been, Lordship, that, some amount has been, my lord, that, budget has been, my lord, just can put, my lord.
Get your instructions. What happened?
my lord, Deputy Commissioner, my lord, accorded, sanction, my lord, and forwarded to the government for allotment of budget.
Good stuff. Now let me get that instruction.
Lordship.
Okay, list the matter again on 21st of August 2024.
Okay.
Your name has been shown?
I have not been shown.
The registry shall show the name of Mr. J.C. Hendig in the cause list appearing on behalf of the respondents.
Obliged, my lord.
I am for the petitioner in item number 39.
What do you want?
The other side is filed in IA for implement of a petitioner.
You want to be made a,
I am the original read petitioner. The
in which case? Well,
item number 39, that is WPC number
your name is what?
My name is Apurva Kumar Hazarika.
Okay, in this, they have filed a petition.
Brother has filed a petition for his implement in this case.
Why? What is the case about?
This is about a building. I have constructed a building in my plot of land, and it is a joint plot of land. The brother has complained, raised complaint that his FAR has been consumed in construction of my building, and so 5th and 6th floors, which I have constructed without permissions, that should not be regularized. That was the case. So thereafter, we preferred an appeal before the mayor in council, and mayor in council has directed to consider there is an observations, and that was not considered, and demolition drive was carried out. Some portion has been demolished. Thereafter, we filed this writ petition against the GMC. Then at that point of time, my brother has filed this IA, seeking that I should be made a party here.
So the root of the problem is your brother.
Yes, Lordship, there is a
Okay, we
dispute.
make him a party. He's the root. Without the root, how can you have the tree? Okay, look. Is an application filed by, you are there.
I am in 40 miles.
Who is the IA?
He is not present.
Who has filed this IA?
I was filed by.
Council is not appealing. I council is not appearing. I council is not appearing.
And who is the petitioner in the other case?
That is, I am respondent number 4 and 5, my lord. That council is petitioner in that case, my lord.
Lordship, this Pradeep Hazarika, who has filed this IA here, he is the petitioner in the other one.
Excellent.
Let us do one thing. None appears on behalf of the applicant on call. To stop. For the ends of justice, the matter stands adjourned to be listed again on 2nd of September 2024. It is made clear that if the applicant is not represented on the next date, this court shall presume that the applicant have lost interest in the instant application.
This IA was filed for amendment of the petition lawsuit.
Amendment of what?
Or addition of my lord, alternate prayer laws.
Huh?
Or addition of prayer laws.
Alternatively, directing the respondents to deem that the land of the petitioner measuring so and so under Lakshmipur in the district has acquired under so and to pay adequate compensation. You want to amend?
To add this, my lord, prayer laws.
You want to amend your claim?
Yes.
Amend your petition by including the prayer? Yes, any objection?
No, no.
Good stuff. The instant application heard Mr. M.H. Hussain. M.H. Ahmed, the learned counsel appearing on behalf of the petitioner, Mr. Public Health. What is this public health? Public health has anybody?
No, health department.
It is public health department.
No, it's health department. Public has been
Health department.
already corrected in the main
It was
petition.
corrected.
Probably again copy paste and
Fine.
it is found.
Okay. Mr. B. Gogoi appears on
Health.
behalf of the health department. And Mr. A. Bhachaji appears on behalf of the revenue department. And Ms. Esburu appears on behalf of the district commissioner Gwalpara and his subordinate. So this is an application seeking amendment of the written statement and of the writ petition to include an alternative prayer to the writ petition. The counsel appearing on behalf of the respondents has no objection to the said amendment so forth. Accordingly, this application stands allowed. And the petitioner herein, applicant herein, who is the petitioner, is directed to file the amended writ petition by serving advance copy to the respondents by 14th of August 2024. Police recording. I think this post.
Please, my lord, as per Rajma Court order, my lord, notice served, my lord.
Service not complete.
That as per the Rajma Court order, complete. Order dated 25/7.
None appears for the petition as per the office note a notice was issued to the respondent by his death. AD. What is the matter about?
My lord, matter is that, my lord, the petitioner's land was demarcated, my lord, in pursuance of the order passed by this honorable High Court, my lord. Thereafter, my lord, it was ascertained that one cantilever and sanitary tank was there, my lord, constructed by the private respondent number 7 to 10, my lord, and some debris are there, my lord. Therefore, my lord, the petitioner filed a petition before the JMC and JMDA, my lord, for removing the same, my lord, taking necessary steps for removing the same, my lord. But they have not responded. Thereafter, my lord, the
No,
petitioner-
there is an order passed in appeal.
Yes, my lord.
Appeal against those private respondents.
No, my lord, the appeal against the order passed by the additional commissioner, my lord, GMC, my lord.
Why are you asking for compliance with the order written 18/1/2024 passed in appeal?
My lord, by that order, my lord.
No, the order says then appeal, there is a direction to the commissioner to comply with the order of the court, my lord. You don't do the needful, my lord.
What to do?
No, there, some enforcements are there, they are to be removed, my lord. After
Which is
the,
being done by the private respondents.
yes.
My lord, there is a order of this court, my lord. The authority has not complied in proper way, my lord. Therefore, challenging that order, the appeal was filed before the mayor in council.
Understood, Mr. Counsel. We do one thing. We cannot accept notice like this in this case because here the action will be made against those private respondents. So we direct you to effect justice service. Where do they stay?
My lord, I think I have to take instruction regarding justice because my lord,
Jason plot
they may not be.
from Maligaon.
Huh?
From Maligaon.
My lord,
Not necessary. If they don't receive, file an affidavit, they don't receive. But route through the area, send it through the anybody, through your clerk, send it through your clerk and get it done. Yeah. Full stop. This court have perused the office note dated 25/7/2024, whereby it has been mentioned that in view of the internet generated track consignment reports, the service upon the respondent number 7 to 10 is complete. So, be that as it may, taking into account the prayer which have been sought, the relief which have been sought for, and it would have serious implications upon the respondent number 7 to 10, this court directs the petitioner to effect service by way of dusty upon the respondent number 7 to 10, routed through the registry of this court and file an affidavit of service on or before the next date. List the matter again on 9th of September 2024.
Okay.
I have informed her, she is next on another court coming, she is coming. After 5 minutes, if possible, if possible, let's take the matter tomorrow, take the matter tomorrow.
No, okay, we ask this person to be present
No,
through
no,
video
she is
conferences
coming,
tomorrow.
she is on the way.
No, tomorrow we have this video conference tomorrow.
Yes, she is coming, Lordship.
Yes, revenue. You are revenue. Who are revenue? Both of you. You see, what was the direction passed by this court is that the petitioners over the land in question and dispose of the providing the respond number 3 may examine the representation dated 21/11/2022 submitted by the petitioner and take appropriate action in the matter as may be permissible under law. If on verification of fact it transpires that the issue projected in the petition raises a civil dispute and therefore requires adjudication by the civil court, it will be open for the concerned authority to express such an opinion in the writing by giving proper reasons. This is the direction. Now, in pursuance to that, the deputy commissioner who is there, district commissioner, he has filed an affidavit. He says that, look here, what I have done, after getting it, I have sent it to the number 2, who is the circle officer. And he has opened a miss case. Then direction was to complete within 2 months.
And competent
What he says, it is further stated that after receiving the forwarding letter of the respondent number 2, has started a process of miss case number so and so have been instituted and accordingly notices were issued to both the parties.
A district commissioner is the competent authority under rule 116.
The district commissioner will have to, my lord, act on the basis of, my lord, report from the cycle officer.
Whatever may be, let him either say that it is a civil dispute, there was a direction to comply, but you can't keep it in just out there. This direction was given in the year 2022. 22. I hope so. 23, 21/8/2023 to do it within 2 months. Now, can you say that in the year 2024, 2024, he says that I've asked them, he has opened up a miss case, matter finished.
Perhaps, my lord, in order to comply, my lord, whether there is a dispute person. If there is no dispute, my lord, then the revenue authority will immediately act, as far as I could comprehend, my lord, from the order. Now, if there is a dispute, then the parties have to be delegated, my lord, to the.
That is the court also said.
Yes.
If there is a dispute, send it to the civil court. Give
Yes,
proper
sir.
reasons.
Yes.
But what is stopping them from passing that order?
No, my lord, I think, my lord, that the deputy commissioner has delegated that authority, my lord, to the circle officer, because since the circle officer is the.
The circle officer is also a party.
No, that's why, my lord, I am making that submission, my lord. Perhaps, my lord, by drawing up that proceeding, he is giving notices to all the parties concerned, my lord. Now, they will appear before the circle officer and they will stake their respective claims. Then on the basis of that, circle officer will pass an order. Now, that order has to be ratified by the deputy commissioner, since that direction was also to the deputy commissioner.
Whatever may be, the deputy commissioner only comes up with this thing. I have asked my circle officer to do, the circle officer has issued notice, matter finished. And this was done in 2000. First, he came, he gives a parawise comments directly to the court. Then thereafter, his court asks the counsel who was representing, Miss Yudas. Yudas, then he files an affidavit on 23/2024. We are in the month of July end. What has happened? There was a direction to do within 2 months.
Perhaps, my lord, an affidavit from the circle officer will be required here, my lord. What is being done there?
Page 10, second paragraph, deputy commissioner is the competent authority under the rule 116. Circle officer is not the authority.
Circle officer is the first officer of at each steps, my lord.
The rule permits
So
the
maybe
deputy
there is a direction, he has to come up and do it within 2 months.
No, definitely. Now, my lord, it is not that, my lord, that what I can comprehend, it is not that the authorities are not doing it. They are doing it, but a bit late, my lord. So to that extent, my lord, for
But
seeking
whoever
compliance,
is appearing on behalf of the deputy commissioner, be there.
they are taking time. Now, it has to be completed within a time-bound manner. Yes. Now, since 2 months have already elapsed, lordship can pass a direction, my lord, that they will
Only
have.
direction is to see the deputy commissioner's face out there in the video conference. That is the only way.
So in order to compel,
Hello.
my lord, compel compliance, that is my submission, my lord. In order to compel compliance.
No, we'll ask him to be present through video conference on today's what date? 29, na? on fifth. On fifth, let us hear from the Deputy Commissioner, what does he have to say? Video conference. He will give us an explanation. In the meantime, if he passes an order, well and fine.
Only time is the constant, what I can comprehend. It is not that they are sitting over the matter. My lord, almost in the late hours, my lord, of course. Very lately, my lord, they have started doing it, my lord. for
Yes,
compliance.
madam.
I'm sorry, my lord, I missed the item, my lord.
We are directing the Deputy Commissioner to be present through video conference. Because you see, the direction which has been passed by this court
My lord,
makes it very clear that within 2 months you have to dispose of the representation.
lordship.
The Deputy Commissioner initially files 2 documents before the court directly, giving para-wise comments that look here, we have done it. I've asked my circle officer to do it. Circle officer has opened a miss case.
My lord,
Thereupon, the court must have held you and you say that you filed an affidavit through the Deputy Commissioner.
my lord,
And that Deputy Commissioner says this on 23/2024.
lordship,
We are in the month of July 2024.
lordship.
What has happened?
May I pray for my lord, fixing on Friday, my lord, I'll try to get it, my lord, instruction.
Okay. The Miss Yudas, appearing on behalf of the respondent number 1 and 2, submits that she obtained the instruction as to what what steps have been taken by the respondents
Right.
in respect to Miss case number 08/2023-24, which was instituted on the basis of the representation submitted by the petitioner. Full stop. List again on Friday to date.
Lordship, deeply obliged.
Obliged. Take one.
It does start to be enough.